Maxwell to read into the record the public disclaimer.
Okay, notice of the November 13th, 2019 meeting of the Real Estate Commission, including date, time, and location, has been noticed on the Tennessee Real Estate website since September 18th, 2018. Additionally, this month's agenda has been posted on the website since Friday, November 8th, 2019.
Call the roll.
Okay. Everyone will just say here. Commissioner Joe Begley.
Here.
Commissioner Jeffrey Diaz.
Here.
Commissioner Rick Douglas. Here. Commissioner Marcia Franks. Commissioner John Moffitt.
Here.
Commissioner Fontaine Taylor.
Here.
Commissioner Stacy Torbett.
Here.
Commissioner Bobby Wood.
Here.
Chairman John Grease.
Here.
You have a quorum.
I'd like to point out that if the executive director asks you to say here, you don't have to. You can click present if you want.
Okay.
But that
Sure,
you're
everybody's clear on that. All right, at this point, I'd like to ask Commissioner Rick Douglas to lead us in our invocation, and when he's finished with that, if you'll stand, we'll pledge allegiance to the flag. Mr. Douglas.
Let's pray. Father, we come to you, Lord, not just part of the agenda, but truly to ask you, Lord, to help us to make thoughtful, fair, and just decisions today. And, Lord, also give us safe travels home. We pray in Jesus' name. Amen. Pledge allegiance. Aye. Public.
One nation. It's my pleasure to welcome officially two new commissioners to the Tennessee Real Estate Commission. To my left is Miss Stacy Torbett from Johnson City, Tennessee, and to my far left is Joe Begley from Kingsport, Tennessee. And on their first trip down here yesterday, they got stuck in a horrendous traffic jam that added somewhere between 2 and 3 hours to their travel time. So if they're not in a good mood, no, this is up on the plateau. This is closer to Crab Orchard. So if you find them a little bit ornery today, that's just because of that traffic, I'm telling you. Do either of you want to say anything? Tell us who you are, where you're from, what you do. We don't put that as a requirement, but if you like, you're welcome to. All right, hearing no comments from either of those two, we will move forward. I want you to...
Might be disappointed.
Already you're starting to talk, Joe. That's good, man. All right, we have an agenda in front of us. Are there any additions or corrections? Mr. Wood?
I'd like to add a couple things if I could. One, I'd like to just give a little report from the National Association of Realtors meeting as it relates to Arello, and we'll talk about that. I'd also like to talk further about the proposed changes that I had from last month. And then finally, I'd like to, and this kind of goes hand in hand with the report from the Arello information from the National Realtors Convention, would talk about maybe some possible IT projects that we might have for the commission.
Do you have a preference where we talk about those?
Absolutely not, wherever you want to put me.
Commission discussion, Mr. Chairman.
I think that's as good a place.
On page 2.
Yeah, very end.
Motion to approve the agenda as amended.
Second.
Second. The motion to approve today's agenda is made by Mr. Diaz, seconded by Mr. Wood. Any further additions, discussion? Let's vote. Those in motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Let's, because I want to wait a minute before Ms. Torbett gets her oath of office back notarized, let's skip down on the agenda for a minute to the executive director report, if you don't mind, Caitlin. I know it's out of order, but let's do that.
Okay, so I just wanted to update everybody on some topics that had come up at the last meeting. So PSI, the scores are now on there. So if you have anybody that has recently taken it, probably within the last, she got it on their PSI got on there pretty quickly after our last meeting, so anybody, I would say definitely within the last 3 weeks, it will now say their actual score on passing.
Just the person
Well, we get a copy as well.
who was score, like if you get a,
We would get a copy, but we wouldn't get a copy if they failed.
point they don't give you the score.
We could see it, but we don't want any. We don't want people submitting anything but passing for the exam.
The great part is the people who took the test, if they passed, they see a score.
Yes.
And
Yes.
yeah, I think that's great. People have been looking for that for a long time, so that's
Yes.
great.
So yeah, it should now be on there. There was a couple questions at the last meeting about Verify. I've been checking it, and it seems to be working. That's not to say that maybe from time to time there's a fluke, but if anybody else hears of that, definitely send it my way and let me know, and I can look into it. But I have been checking it, and it has been working to show status and education.
Contact information.
You're muted, John. There you go.
It's technical stuff. So thank you very much. It doesn't show, like if I want to find somebody's broker, I still don't know how to do that.
Yes, it still does not do that. We're working to get everybody's firm on there, what firm they're with. That is on probably about half of licensees right now. And I've talked to IT about where that is in our system so that it can reflect on there in the attention section. But yes, and part of that is that we are an umbrella agency, and so it's not, Verify is not just built for real estate agents. It's built for cosmetologists, architects, engineers, accountants. So I know that they are looking in the future to transition it. And so at that time, it could be something that we look into to see whether we could have that option.
Much cash as we have stashed away, could we not just, I know we can't, but it would make sense to me that if we're so different from every other regulatory agency that we might have our own data, but I guess not.
I think it is potentially something that could be done when they do move the system. It's going to have all the same things.
Legal counsel's reviewing the notary seal, is it correct? All right.
Okay, moving on. We're
Okay.
going to get the AG opinion added to the website. I know somebody had requested that last meeting. And we have the final draft of the newsletter up to our communications director, so hopefully that will go out by Friday. And we'll get back on the quarterly schedule for that. One idea that Ross and I had floated that maybe we can talk more about is improving the instructor manual. It's something that hasn't been updated in a time. And so we had a discussion about really making it something beneficial, probably maybe like a video or almost more of like a course format. Right now it's a manual. I know that there had been a lot of questions about education, a lot of questions about instructors. And so we thought that that would be a good starting place before they even become licensed, really making sure that they understand what it takes to be an instructor. We highlight our laws and rules, those sort of things. So that was an idea that we had also floated. So we have had one employee leave. Her last day was, I guess it was last Thursday. So we are actively hiring for that. We posted the position as soon as we found out that she was leaving. So we are short one staff member currently, but hoping to get filled pretty quickly.
All right, any questions from Ms. Maxwell regarding her report? I did some quick math, and it looks like your staff is dealing with 41,000 active licenses in some form or another, which is a huge number.
Yes, yeah,
Huge.
all-time high.
So I declare it the largest number of licenses the Real Estate Commission has ever dealt with,
Yes.
just for the record.
It is, yeah.
Okay.
The
Well,
other thing I was going to update on was that many of you probably saw that the fee reduction rules now are into effect. And I can go into a little bit more detail later, but it wasn't a quick process. We started that roughly in May 2018, and they went into effect November 3rd, 2019. And that's not anything to do with anyone here. It's just, it was a long process. So,
We have proposed rules today. Would you think it would take a similar length of time?
that might be a question for legal, but with the one thing I will say is that pretty much all rules moving forward, they've asked that we do it via hearing rather than proposed.
Does that mean
Rulemaking hearing.
more time?
Yeah, it takes a little bit more time to do that. And even if, with the rules that we have today, I would not recommend them going the proposed route anyway. So we'll get more into that later. But with rulemaking hearing, it does take a little bit more time. But the hearing we can have. The good thing about this commission is you meet monthly. So some of our other boards meet quarterly, so we have to wait a little bit longer, but we can set those hearings whenever it comes in with the timing after it's gone. So we'll get into it more later.
Any other questions or comments for Ms. Maxwell? You have the right throughout this entire meeting to interrupt anybody and ask her any question you want to at any time. I don't want you to think we're done with her. All right, let's get on to the minutes of last month's meeting. You all were sent those electronically. Is there a motion? Motion by Mr. Diaz to approve the minutes as presented, seconded by Ms. Taylor. Discussion, any corrections or additions? Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. All right, next up we have 3 informal appearances on our schedule. Is Mr. Tate here? Let me just check. Ellen DeTore, she's here. Lawrence Jones. All right. For the benefit of you 3 people and new members of this commission, this is how our informal appearance works. We will, when your name is called, we will ask you to come up along with your proposed broker, and Ms. Matlock, who's an attorney with the Tennessee Department of Commerce and Insurance, will ask you to swear to tell the truth, at which point you have to say yes or no, but we hope you'll say yes. Following that, Ms. Maxwell will read just a short blurb about why you're here, and when that's done, we'll ask you, as the applicant, to tell us what this is all about. You can tell us as much as you want to or as little as you want to, with the understanding that when you're done talking, members of this commission can ask you any question they would like as they try to decide whether to let you move forward or not. Following our interview with you, if there are questions, we'll ask the broker who's with you why he or she is interested in having you affiliate with his or her firm. Broker gets to respond. Commission can ask questions of the broker or go back and ask questions of the applicant again. But at some point, there'll be a motion up here that will either be to allow you to go forward to get your license or to say, we don't think it's the right time. Okay? So that's kind of how this works. So, Antonio Tate, you're first on my list, so if you'll come up with your broker and come to these 2 chairs right here. Ms. Matlock, if you'll swear those 2 in, please.
Light is on.
To each person that comes up here, we are these sessions are being streamed live, and so we need for you to speak into the microphone for the benefit of the people who are watching it, and also for the benefit of at least 2 or 3 of the commissioners up here who have a hard time hearing. Speaking for myself. All right, Ms. Maxwell.
Before you, you have applicant Antonio Tate and his principal broker, Gail Brown. Ms. Brown was first licensed in 1989 and became a broker in 2000. The firm is Exit Master Realty, and a summary of the disciplinary sanction is felony possession with intent. A disposition of the felony can be found on your iPads, as well as a statement and letter of recommendation.
All right, Mr. Tate, tell us what you'd like for us to know.
That was pretty cut clear. You know, I'm just trying to get licensed from, you know, some things on my past.
So that's a pretty brief statement. How about when did this happen? Where were you? What were you doing in your life at the time? What have you been doing since? Any of those things could be helpful to us.
At that time, I was working. I'm currently working, and you know, I'm always working. You know, it hadn't, you know, affected anything since then. You know, I just wanted to get past the past and, you know, move forward.
So how far back in the past are we talking about?
10 years.
See, that's important to know.
You're right. Right.
Okay. And if you'd like for us to know how this came about, I think you gave us a written statement, but for the record, not all of us may have read that yet. So,
Yeah, I was in the car with somebody, and you know, we got pulled over, and it was in the car.
all right, I pulled all I can out of you.
I was in a car riding, and the car had dark windows on it, and you know, they pulled us over, and you know, it was 2 ounces of cocaine in the car.
Mr. Tate, is this a situation where the drugs were in the car, and so under the law, everybody in the car was held responsible for it, or?
No, I was held responsible for it.
Okay. So it was yours, it wasn't the driver's?
Yeah, it was mine.
Okay.
That's one of the first times anybody's ever told us it was theirs.
Right.
I've always said it was somebody else's in the car. Mr. Diaz, anything else?
No, thank you, Mr.
Ms.
Chair.
Taylor?
I think what we'd like to hear is that that you were caught with this, and you were caught with what?
2 ounces of cocaine.
And you were doing what with that cocaine?
Going to drop it off.
Drop it off where? You were selling it, or just using it?
Yeah, I was selling it.
Selling it.
Yes, ma'am.
All right. So after the time of selling that, so you were taken to jail, right? Or and fined for selling it? Is that correct?
No fine for possession.
Possession. All right.
Yes.
And so, did you serve any time?
No, I didn't. It was probation for 8 years.
8 years. And
Yes.
so, have you been selling any drugs since that time?
I wouldn't dare.
Pardon?
No, ma'am, I wouldn't.
And what have you been doing since that time with
Well,
your life?
I've been on my job for 23 years.
All right. What is your job?
I'm a technical specialist.
All
you
right.
know,
Great.
for the city.
So you're still doing that same job. You've been hired there this whole time then?
Yes, ma'am.
All right. Have you changed? Do you stay around drugs at any time anymore?
Oh, I'm active in real estate. I'm building and you know doing different things like that. So my time is going toward you know a career,
Now, you
professional career.
say
legal.
you're active in real estate in what way?
Just fixing flips and building and things like that, developing.
But you're selling real estate or showing it or just?
No, I'm not selling
All
real
right.
estate.
Okay.
I'm
That's
just
what I
doing my.
wanted to make sure.
No, I'm doing my own.
All right. So you've changed your lifestyle then, or just this was just a bump in the road and you keep going?
That was just a pass. That was my pass, and yeah, I changed. Yes, ma'am, I changed.
So, Antonio, did you see how much better she did asking you questions than I
Right.
did? Those are the kind of things we're looking for. All right, other commissioners. Mr. Douglas.
Yes, so it says here that you have been on your job for 23 years,
Yes,
and this incident occurred 10 years ago.
yes, sir.
Did you not lose your job?
No, I didn't.
Okay, and you were with the city?
Yes.
Okay. Can you tell me why didn't you lose your job, and did you spend time in jail for this?
No, I didn't spend any time in jail. It was probation.
Were you put under suspension with your job, or?
No, I wasn't.
Okay. Question I have right now.
Good.
Did your job know that this happened?
I didn't report it, to be honest.
I just, most of the time we have people come. I mean, they understand that we have the ability to kind of help them here, and they're just a little more forthcoming, and that's a little concerning. That it's been really hard. I think you've got commissioners here that have really tried to help you this morning, and when people just don't. They're not very forthcoming. It leads me to believe there's a reason for them not to be forthcoming, and that's a concern. I mean, just like what we just found out, you didn't even bother telling your job, and that's a concern to me too. So,
I mean, it's not a problem for me to tell my job. I mean, I work at Public Works. You know, I've been there for 23 years, going on 24.
Douglas?
So you were selling the drugs, but you were also a user, I assume?
No, sir.
No? Just selling? Yeah. I just find it interesting that you were charged with this crime and you didn't spend any jail time, but you were on probation, but you worked for the city in Public Works and they didn't know anything about it. Okay.
Mr. Diaz?
Counsel, what are the rules about licensees reporting any felony convictions or any of that? What's the time?
So if a licensee is convicted while you are licensed, you're required to notify the commission within 60 days of the conviction. If not, then your license shall be revoked.
By statute, this
That's
commission
by
has
statute.
no discretion to that matter.
No.
Okay. So while I don't expect there to be another felony conviction, I want you to be aware that you have a responsibility to notify TREC should it happen again. I understand, but
Okay,
I just want to be
right.
on notice that is a rule.
I understand.
And, I'd hate for you to get into your career and have a practice built up, and then you hit a bump again
On it, yeah.
and ruin it and have your license revoked.
Taylor?
I think what we want, I know what I want to hear from you is that you have some remorse or regret for what you've done, and going forward that you've changed your thinking about certain things. And I'm not hearing that.
It's a lot of regret, from my past, and I am, changing every day.
All right, other questions for Mr. Tate? Ms. Brown, would you tell us why you'd like Mr. Tate to be associated with your firm that you're responsible for?
Well, Mr. Tate's
You're going to have to get close to that for help me out a little bit. You may have to move. I don't think they do.
Can you hear me now?
Yes, thank you.
Mr. Tate is a little short on words, but his wife is one of my agents. And she's been with my firm for 2 years, and they work and develop their own properties. They build, they sell. They have been active in developing their own small company, and they want to partner as agents together to do more team building. I can say about Mr. Tate, he's not one of those people that's out there in the streets slinging drugs and acting crazy. He's working every day, and his wife works every day. And he made some dumb mistakes that a lot of people make in life. He's not addicted to drugs. He's not a drug addict. He was trying to hustle money to support his family. You get that dream, get rich quick thing, and it don't ever work. What works is hard work. And he has learned that lesson, and I vouch for him because I've watched him with his wife do a lot of positive things in the community. I've watched them build quality homes. I've watched them sell quality homes. I've watched them do good real estate contracting and follow the rules and stay focused. His wife is very diligent about her contracts. She stays in constant contact with me on everything that she does. So it's not difficult to supervise her. And through her, I've learned a lot about him. And so I vouch for him because I think he would make an excellent addition to the real estate community. But I also think that as a person, he's a good person who made a bad decision. And bad decisions follow you, okay? But the fact he's been on that job all those years, I don't know very many people that can keep a job for 23 years. It's like, in this day and time, people stay in their job 2 or 3 years and they're rolling over somewhere else. But he is loyal, and he's hardworking, and he's focused, and I don't see any shyster activity from him. I see him doing above board, legal, ethical business. And I think that that's an asset to the real estate community.
Commissioners, Mr. Douglas.
I just think he's got a good advocate there. And
She knows how to talk, and he does.
She does.
Is that what you're saying?
you can learn a lot from her, for sure.
He's a man of few words, let me just say that.
Fontaine,
I would like to know.
come up to the microphone. Fontaine.
When he becomes should he become an agent with you, what do you intend to do to supervise him?
Well, him, like all of my agents, I'm a small brokerage. I only have 9 agents, and I'm a hands-on kind of broker. I came up 30 years ago when we had to handwrite everything, and we had to go to our broker for direction. My first contract, my broker sat down and wrote it with me because that's the way it was. And you had to hand carry everything. Because of the way I was trained in this industry, I treat my agents the same way. I'm an exit real estate broker, and because of the franchise I'm in, they're into growing big companies with adding as many licenses as you can. I'm kind of maintaining the pace that I'm maintaining because I am hands-on with my agents. And they call me 24/7. I'm not one of those agents that works 9 to 5 and you don't hear from me on the weekend and my phone is unlisted. You know, I'm available to my clients as well as my agents. And because of that, I stay on top of them following the correct rules, regulations, and laws, because this is an industry I've invested my life in. And I don't want anybody in it with me that's not on the same path of trying to be a good agent. His wife has shown me she's a good agent, and I believe that he'll be a good agent, or I wouldn't be here today.
Mr. Diaz.
Mr. Tate, just going back to you, how old were you at the conviction?
42.
You were 42, 10 years ago. How long you
Oh,
been?
no, today I am.
Today you are, so you were 32.
32.
All right, so not a younger person that should have known better at that point. How long you been married?
Married for 18.
18 years. Does she run you?
But
Somewhat. I think at 18 years.
You need to get the microphone closer to you to answer that particular question.
Yeah. You want to restate your answer, Mr. Tate? She do? Okay. Okay. That's okay. I get run too. It's fine. I notice here that the date of probation end says 3/2019. Council, are we on the Fresh Start Act here? Because don't we require 2 years from the time the judgment ends by the rule? 2 years?
Sorry, will you repeat the question?
2 years from when the probation ends to be considered for a license?
Yes, that's as the rule is written now, but because of the Fresh Start implications, that's why he's here today.
Okay. Thank you.
Other questions? Mr. Tate, I typically make my decision not based on the testimony of the applicant, but on what the broker says, because she, in this case, is ultimately responsible for your actions. If you screw up, we bring you back and your broker. I don't get the sense you want to come back here anytime soon, either one
No,
of you.
sir. Not unless it's something positive.
Now, yeah, if we have an award for you or something. Mr. Tate's your top salesman next year, you bring him back and tell us, okay? We'd like to know about that. But with that said, I think Mr. Wood brought this to my attention. You know, you're saying you're going to affiliate with Ms. Brown, but tomorrow, as soon as you get your license, you could take it anywhere. You don't have any intention of doing that, do you?
no,
That was short again. Anyhow, the chair at this point is open for a motion.
I'd like to make a motion that we approve.
I've got a motion by Mr. Douglas, seconded by Mr. Moffett, that Mr. Tate be allowed to continue to get his real estate license. If this motion passes, you'll be allowed to do that. You've got to get 5 votes, okay? Any other discussion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Don't let us down. Don't let her down. Don't let your wife down. All right, guys. Good luck to you. Thanks for coming down.
Thank you so much.
All right, Ms. Dettori, and I'm sorry, I'm not sure that's how you say your name, but please come up with your broker, who looks familiar. Oh, Miss Ellen, is it Dettori? Okay, great, thank you. Thank you. All right, Ms. Maxwell.
Okay, before you, you have applicant Ellen DeTore. Her principal broker, Kurt Steckel, has been licensed since 1987 and received his broker's license in 1992. The firm is Dream Team Franklin, doing business as Keller Williams. A summary of the criminal disciplinary sanction is misdemeanor theft by check. The disposition and the charge can be found on your iPads, and I believe you have a printout letter of recommendation.
From Forte Vacation
Yes.
Rentals? Okay. All right, so you've just had to go through this stretched out hearing with Mr. Tate because he wouldn't talk in detail. Would you mind telling us what happened? I've read your narrative, and I'm sympathetic to it, but for the record, would you let us know?
I moved to Texas from Atlanta. I'm a licensed real estate agent in Atlanta, Georgia, and I moved to Texas in 2010.
Closer, local.
In 2010, when my husband became ill, and we moved to Houston, and we sought his treatment, and he passed away in 2011, and I stayed in Houston after leaving my license on inactive in Georgia. And then in 2013, I thought I met a wonderful person, and I did not. And I moved to Abilene, Texas. And in Abilene, Texas, I had left my bank account open that was open in Wells Fargo out of Houston. And there are no Wells Fargo banks, believe it or not, in Abilene, Texas. And so I was having a direct deposit, and a check was written out of Wells Fargo in October of 2013. And I didn't realize that I was in a bliss, I think, of trying to find happiness again. And I was getting married in December of 2013, a couple years after my husband had passed, and didn't realize that this check had not cleared. And I left that account open for 6 months and returned to Houston in March of 2014. And that's when I closed the Wells Fargo account. I had opened up a Bank of America account previously because I didn't want to use Wells Fargo because there was no branches for me to go to. And then I returned, like I said, to Abilene and thought I was living my life until I got a speeding ticket and someone said, "There's a warrant." And I said, "What?" There's a what? And I had no idea. I was clueless on all of it because my address had changed and my last name had changed, and there was no one asking me anything. So it was hard. I was shocked. So after that ticket and the police officer saying, "There's definitely a problem here. This is definitely not right." And I said, "I know." And so she took me down to the station, and she said, "The only way to get you out of the system is to get you through the system." And she said, "You're going to have to go through this, but sit right here." And so I was at that station and out of that station in less than 2 hours. It was just quick. And then I went and paid the check and paid $100 on fines. There was no probation. There was nothing. I was done. And I pled nolo because I was clueless. I had no idea this happened. And then I left that person that I was married to because I did not realize that he married me for money. And so I had to leave that marriage after 15 months. And it was a good thing. And I went back to the name that I was married to for almost 20 years, which is DeTore. And then I got licensed in Texas in 2016. And I run a property management company there and sell real estate there.
Let me ask one question, so I'm clear on this. So you wrote a check, you forgot you wrote the check, you closed the account, the check wouldn't clear, and somebody filed a warrant.
Yes.
Okay, that's how you got here.
That's exactly right.
Okay, just want to see if I've got it. Commissioners, questions? Yes, ma'am. Ms. Torbett.
How much was the check for?
$60. And it was dismissed down to a dishonorable check and not theft.
Other questions?
That was my exact question. I'm just trying to figure out what the big fuss was over. Okay.
Yeah, this is certainly such an easily forgivable offense because you had no knowledge of it. It wasn't anything you did set out to do. It was just because of I understand that, and I
At the
think
moment,
it's clear.
At the moment, you're licensed in Texas and in Georgia. Did either of those state agencies have anything to say about this? Okay. The only question I have, staff, is on the application on page 2. First, have you ever been convicted or pled nolo contendere? And you did plead nolo?
I pled nolo because I didn't know what to do when.
I think testimony overrules, or supersedes this, but for the record, that probably should have been checked yes. All right. Other questions for Ms. DeTore? Mr. Wood?
Was your husband at MD Anderson? Is that why you went to?
I tried. They were too full.
Okay.
He had stage 4 colon cancer.
Okay.
So we went to Memorial Hermann.
My brother went down there. So.
All right. Mr. Steckel, I sense that the commission is done with Ms. DeTore, at least for the moment. How about comments from you on why you'd like to have her affiliated with your firm?
I feel, based on my conversation with the reference, based on her attending training classes already at the office, and based where she's already producing as an agent in Texas and Georgia, I am very comfortable for her coming on board with us. Very comfortable.
Commissioners, any questions? If not, there's no need, I sense, to stretch this out. Is there a motion?
Motion to approve.
Motion by Mr. Diaz, second by Mr. Moffitt, that Mrs. DeTore's application be approved and she proceed to get her Tennessee license. Further discussion. Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Best of luck to you. Good, and I suspect you'll do fine. Thank you, sir. All right, Mr. Jones, please. You've seen how this routine works.
I said.
So I don't think we have any paperwork
We
on
don't
this.
have any.
On the-
Would you like for us to print it out for everybody?
If you'll just tell us the nature of what we're dealing with, then we can
Okay.
probably decide on that.
Okay. Before you, you have applicant Lawrence Jones and his principal broker, Christopher Claybo. Mr. Claybo was first licensed in 1996 and became a broker in 2006. The firm is Wyndham Vacation Resorts, Inc., Nashville. A summary of the criminal and disciplinary sanction is felony sale of controlled substance. This says the statement can be found on his iPads, but clearly that's not the case.
So, Commission, we can ask to get stuff printed and postpone this a little bit, or we can take a chance with these two guys and let them try to tell us what happened and see if we want printed material following their conversation.
I say we
Proceed. All right, Mr. Jones, we're working blind here. I don't know how to guide you at all on this, so tell us why you're here today.
In 2004, I started to attend MTSU. And upon me attending MTSU, I was married at the time. I had married a young lady that I went to high school with. At that time, we had 2 children, and I decided to get my GED and go to college, in which I did that. In the midst of that, we had 2 more children, and a couple of my classmates, they sold drugs. And when I seen the money, you know, we were kind of strapped for cash. But when I seen it, I was like, wow, how did you guys make that? And, they explained it to me, and of course, I was like, well, I would love to try to, make that kind of money, help me out through college and kids. And turned out it backfired. One of the gentlemen, one of the guys, his name was Leon. Leon was actually, I didn't know that at the time, but it was a circle of those guys. But Leon was actually an undercover ATF agent. And what had happened was the ATF did what was called buy walks or something to that nature. So everybody in that realm, including my brother, we all were charged with the sale of controlled substance. So from that point, of course, I pled guilty because I was accountable. I did make that choice. So from there, I went into TDOC custody for the sale of the controlled substance. When I got into TDOC, they seen that it was a first-time felony offense, so they said, well, we're going to override this, Mr. Jones, and we're going to allow you to go to boot camp. If you make it out of boot camp, then you can re-enter society. I went to boot camp. I gave it 110%. I actually became one of the commanders in boot camp. During my time in boot camp, I had to attend a pro-social life skills class. I had to attend anger management classes, and I also had to attend drug rehabilitation programs, which I successfully did that. I came out of boot camp in 2013, and 2014, I started in the automotive industry, selling cars. And from there, I just wanted to build a little more success within myself. And the reason I say that is because I owe a due diligence to my family. One thing I didn't think about when the money concept was in my mind frame, one thing I didn't think about is, going to prison or losing your life. You have these babies, you have this wife. It causes a ripple effect. I lost my marriage, lost everything. But Pastor Enoch Fuzz is a great guy. He's a friend of my mom's. He's been my mentor since I got out. And from there, I received an opportunity to work with Wyndham, and which I had applied for them 3 times, actually. So the third time, they actually had cleared me and was like, yes, we'd love to have you as a part of our team. And I'm here now because of the situation that I brought upon myself in my past.
All right. So 2013 was the date that you were arrested, or was that when you were done?
That's when I got out of boot camp. I got out of boot camp in March of 2013.
So probation?
Yes, I had to, when I came out of boot camp, they gave me what was called community boot camp supervision. So I guess it's sort of like probation, but it's because they changed. TDOC it used to be Board of Probations and Parole, but TDOC acquired that. So it's just like probation, but I have to.
When were you convicted?
It was in 2011, 2012.
When were you? So probation, whatever it's called. When were you done with that?
I'm actually that ends in March of 2020. So I have 3 months left of that.
Matlock, are we okay with that?
Yeah.
So we've got this rule. Just for the record, we have this rule, but we need to ignore it based on new legislation that's passed.
Well, we're not necessarily ignoring the rule. It's just that with the passing of the Fresh Start Act, we believe that instead of denying an applicant based on the rule, it would be best to have them come be presented before the commission, not to run afoul with the statute that's already been passed.
All right, thank you.
And so we're presenting something later on that.
You're okay with us considering this?
Yes,
That's
I
what I
am.
want to hear. All right, Commissioners, questions for Mr. Jones? Mr. Diaz? No. Anybody else?
I think you spoke very well and explained your situation very well, and I appreciate
Thank you.
your forthrightness, and thank you.
All right, Mr. Claybo, what do you know about this guy, and why do you want him?
Good morning, y'all. Actually, I was thinking the last 2-3 times I've been here, the answer's always been somewhat generic. We're a big firm. We have our own internal background checks that we do. We have a hiring process that runs through 4 or 5 different management leader staff. We had a 2-week training class, which he did very well in, and he's well-spoken. We enjoy him. But I was thinking driving in here, though, this is the 4th time we've done it, so I thought about the last 3 times that I got to see you guys. And I thought about the gentlemen that were sitting with me the last 3 times, and all 3 of those guys were in the same boat where they've had decisions in the past that there were bad decisions and lifestyles that had to be removed and relearned, right? And all 3 of those gentlemen are a pleasure to work with. Their need and desire to be successful and move forward and do great business and listen and be moldable is the best of all of our group. And so when I met Lawrence, I was like, you feel in that exact same seat that they have been in, and we're really excited to give new opportunities to people that really want to change their life.
All right, Commissioners. Is there a motion?
Make the motion. We allow them to move along with being licensed.
Second. All right, the motion by Mr. Wood is seconded by Ms. Taylor. One quick question, Mr. Claybo, where do you see him fitting in? What's he going to be doing? I know you timeshare people have different descriptive.
Yes, so far on our side, he is going to be part of our member services, which he will be directly talking to just already existing owners of our product.
Is there a title for that position?
For us, we call it in-house sales.
I know what an acquisition agent is, I think, now.
An acquisition agent is technically
out in the streets.
Out in the streets,
I got it.
He is just going to be servicing our current clients.
Perfect. All right, the motion is to allow Mr. Jones to proceed to get his timeshare license. Is that what we're looking for? All right. Any further discussion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Good luck, Mr. Jones. Mr. Claybo, I have a couple more questions for you.
Yes, sir.
Margaritaville, is that where you guys are?
Yeah, we just opened that up.
How's it going?
So far, so good. It's a beautiful facility down there, around right behind the Bridgestone down there, and we started last Friday actually doing business. We got our licensing all taken care of a couple weeks ago. Beautiful facility.
Have you seen Jimmy Buffett?
You know what? I keep waiting. One of these days.
And how many floors do you have? The top 3 or 4 floors?
Actually, we only have 2.
2.
They're not the tops. I think we have 5 and 6 are our floors that we actually are part of our affiliation.
Oh, the Darby Campbell. Do you know that name? That's all right. Don't worry about it. So is there any place else you're working in Nashville right now? I love the concept of blending timeshare with hotel. I thought that's pretty cool when I heard it.
I agree. I'm a big fan of that as well. Of course, we've got the sales facility there on 2nd Avenue, right next to Rock Bottom. We have our facility over by the Opryland, and then you got the Margaritaville that's there on 5th Avenue.
I have one more question.
Yes, sir.
So we get complaints every month about timeshares, and people say that, and maybe it's just prescriptive narrative, say the salesman badgered us to the point where we had no choice but to sign. And we've never found a timeshare guilty of doing that because everything is documented. But do you all ever record those sessions just to have some?
Actually, we don't record the conversations up through the sale, but after a sale has been agreed upon by the client and ourselves, they go through a video, audio recorded closing where all aspects of the contract, and it's a very detailed 30, 45-minute closing that is line by line, item, signed, checked, videotaped. And we're finding now that we're doing that, it's only been done maybe for the last year or so for us, that there's been a dramatic change in the amount of complaints because it's not as easy as just lying to us. And I hate to say that, but a lot of people will use outside influences and blame us for something that wasn't true.
Did we talk last time about those people that are advertising to get your clients out of their timeshare?
We mentioned it, yes, sir.
We did mention that, didn't we? And didn't I suggest if you thought they were crooks, like I think you said, that you ought to go ahead and file a complaint on behalf of your client, Windsor?
I still feel, even if it's not illegal business, it's bad business is what a lot of them are doing, and it's unfortunate that that's part of that business.
Anyhow, thanks for taking my questions.
Anytime.
Back to Mr. Jones. Good luck. We like this guy, and we like where you're going to be. I hope you'll do him well. Thanks, guys.
Appreciate you.
All right, we have next on our schedule medical waivers. We don't have to have people present for this anymore. Is that right, Kaylin?
No.
Okay. Give me a second to try to find it here.
And I would just ask if we could hold off on the first one, Jeffrey Gadd. I think it'd be better to present that one at the next meeting.
Motion to defer Mr. Gadd's request till December.
I mean, I can explain. When I reviewed this, typically the process is that these requests come through via staff, and they create the form and make sure that they have the medical note and the waiver in a letter to the commission. On this particular one, this agent would like to renew and then go into retired status, but they do not currently have the education, and they cannot go into retired status without the education, nor can they renew their license. So I think it would be better to present this to the commission once they've completed their education.
Motion to defer.
Yes, makes a motion that Mr. Bagley seconds that we defer this item until next month. Discussion?
So now they have to have their education to get the license active, not to retired. Is that right?
They have to be in an active status in order to go into retirement.
Right.
And so this applicant expired in June of 2019.
Okay.
So their license would not renew anyways because they've not done the education.
Okay.
So you really don't even need to consider that they're going into retirement, other than I guess they might want you to know that they're not going to be practicing.
All right, the motion is to defer Mr. Gadd's request until December meeting. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Mr. Johnson, what do we have?
Before you, you have a medical waiver request for Philip Johnson. His license expired December of 2018. The fee request is for $900. He was in a retired status with his license, so he did not have the requirement of education or E&O. He's seeking to have the $900 penalty waived and pay just the renewal fee to remain in retirement. And there should be a medical note and a letter as well.
Benefit of commissioners generally. Tell us how that $900 figure is arrived at.
Yes. So as soon as you pass your expiration date, there is a late fee that you begin to accrue. For the first 120 days, it's $50. Every month after that, it's $100. And after 1 year, you cannot renew. You must retest and reapply. So you have until the 1 year mark to renew with a fee.
Push it to the limit. What's the total penalty?
Roughly $1,000.
So this guy's close.
Close.
Yeah, okay. All right, commissioners, questions?
And he's also within about a month of having to start all over again. Isn't that right?
I'm not exactly sure when his first communication to us was. It looks like sometime around the end in October, but yes.
So, Caitlin, it's at the discretion of the commission as to whether we grant the waiver and allow the refund of money. Has he paid this money and wants it back, or does he just not want to pay it?
I don't think he's paid any money to date. Typically, we like to have them pay at least the renewal fee because that's going to be required regardless. But it's my understanding that he has not paid anything yet.
Right. Finally, he has provided, or a doctor has provided a brief letter to justify his request.
I noticed it in his letter. Not the doctor's letter, but the applicant's letter. I mean, he's saying something. If he's not necessarily asking for a full relief, he just likes some relief. To me, the letter from the doctor was thin. I mean, I think he could have written that letter about a lot of people. I mean, so I'm wondering, have we ever done it where we've said we won't waive the full $900, but maybe we'll waive and maybe make it $500 or something late? I mean, he has some responsibility in this whole thing.
I think we can do whatever we want to.
Okay.
And the rule just says a doctor's note. It doesn't necessarily say, what it has to say.
I'm just comparing
but-
it to other notes we've
Yes.
seen. We've seen some extensive notes, and then this,
Yes, Stacy.
So the doctor's note is from Florida. Does he live in Florida or does he live here?
He said something about maybe moving back to Tennessee at some point, buying a house, I think it said. So
I could look him up in Core and see exactly what address we have for him. I don't know off the top of my head exactly where he lives.
Nope, that's it.
Yeah.
Ms. Maxwell, if, let's say, his license, he goes past the 1-year mark, and he has to start over if he wants to continue his license. So this potentially $1,000 fee would still be there. He would have
No.
So that all goes
If
away?
you retest and reapply, you're basically
So clean slate.
starting as you pay the initial fee, the initial licensure fee, and you have to retake the exam.
Bobby?
okay, let me just throw something out there, and we'll see. How about if we might give him we'll allow him to move forward, but we have a $450 penalty, and then he also has to pay his license renewal fee on top of that.
Is there a second to that motion?
I'll second it.
Thank you, Ms. Taylor. So the motion on the floor, if it passes, would allow Mr. Johnson to pay a reduced penalty of $450 plus his $80 renewal fee so that his license would be active, so at that point he could put it into retirement.
Yes.
Do we need to have a time frame on that? Because his time frame's running out. Would it be within
He would
like
just have
10
a month.
days or something? What would it be?
I think you would have until his license, it's been a year.
Until 12/13.
Pretty much constrained anyhow. He's got like a month to get
Well,
this.
so, okay, but I would have an end to that. I would have it by that time frame. Just,
Maybe just in the communication with him and just remind him, and you've got until this deadline or he gets to start all over.
for us to receive.
My guess is he's figured that out.
For us to receive the money, yeah.
That's why we got this letter from the doctor.
Yeah, I
So,
got you. I think he has, but
Yeah.
I'd just like to tie that.
Yep. We'll make sure to include that it needs to be paid and received by 12/13.
All right, the motion you've heard, is there further discussion on the motion? I'll repeat it quickly. A reduced penalty, are we calling it a penalty, or what are we calling this? Not a penalty, is it?
Late fee.
Reduced late fee of, the total's $450 plus the $80 fee to renew for a total of $530. And it must be paid before December 13th of this year, or it's all for naught.
Test and replay.
Yeah, he's got to start over. That's what's in front of him and us. Let's vote. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. All right, let's take a 10-minute break. Mr. White, you'll be next. All right. Let me step out of order just for a minute to introduce Mr. John Spear. Mr. Spear, is it Spear or Spears? Spear. No S at the end. All right. Mr. Spear, please come to that microphone right over there. He's in charge of every lawyer in this building, as far as I can tell. Would you introduce yourself and tell us what you do, sir? Get close to that microphone. I have to tell everybody that.
Department of Commerce and Insurance. Redemption.
other agencies.
So, John, can we call you John? Is that okay? Or do you want Mr. Okay, just checking. How many regulatory boards do you oversee?
Well, the department has 24, 25. Range of
So what about like legalized gambling? I noticed there, is that under the purview of the Department of Commerce and Insurance?
I'm sorry.
Gambling, there's a new board.
Betting?
Sports, is it sports betting? Sports betting.
Oh, gambling. I was, no.
That's not us, not
The
you.
closest that we would get to gambling is when we were in court, and that's a gamble.
But you've got mixed martial arts and embalmers and all.
Athletic.
Got it. Well, thanks for stopping down and saying hello to us. I think we want you to come anytime you want to. But please do it when there are a lot of attorneys in the room, okay? Because I think that you'll impress them.
Thank you very much.
Thanks, sir.
Thank you.
All right, Ross White, we're going to go to the education report.
Thank you, Mr. Chairman, members of the commission. My light is on here, I see. I want to call your attention to the November education agenda. Just want to say that I have reviewed all the providers, the courses, and the instructors that you see on that agenda today, and I would like to present N1 through N19 to you for your approval, Commission.
Mr. Diaz.
Mr. White, does this include the courses that were deferred from last month's meeting?
Well, there was one course that was deferred, the Tennessee Real Estate College, which is on the discussion at the end of that. The other three were approved.
Okay. Is that the block of 7 courses?
Yes, this is the block of 7 courses that the individual, Mr. Gray of the Kentucky Tennessee Real Estate College, essentially put together for us, and I had spoken with him, wanted to bring back to the commission. If you're ready to discuss that, we can do that.
Oh, let's get these courses first. So N1 through N19 are courses we've never seen before.
Yes.
Motion to approve.
Second.
Motion by Mr. Diaz, seconded by Mr. Wood, that the education director's recommendation be adopted and courses N1 through N19 be approved. Discussion?
I had, no.
Go, no.
No, after
Okay.
we have the vote.
Discussion? If not, let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. All right, Mr. White, an instructor.
Mr. Chair.
You got us one instructor to approve?
One instructor I'd like to present to you as well. I'm going to call that, it should be on your iPad, Shannon L. Musgrave.
What's your recommendation?
I recommend that we would approve that instructor.
Commission?
Motion to approve.
Second. I have a motion by Mr. Diaz, second by Ms. Taylor, that the education director's report be adopted or recommendation be adopted and that Ms. Musgrave be approved. Discussion. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Now back to Ms. Taylor.
You know how picky I am. So I'm starting. Number N9, the last sentence in the middle there, making the realtor.
Should be capitalized.
Thank you.
My apologies to Commissioner and Commission.
Person was, I hope you'll make sure they get that straight.
Right. Got some training. They're correcting themselves now.
Well, we've got 2 or 3 in here, too.
All right.
I think that staff person should have to stay outside for a little bit.
So back to Mr. Diaz's concern regarding course 016, which was deferred until this month. That's next up. You want to give us a little background for new members before we get started?
Yes, sir. Mr. Chairman and the new members, and welcome to the commission. I just want to say I met both at the break, and if I can help them in any way, shape, or form, please let me know. This is a broker course, and what it entails is a 30-hour, well, actually 120-hour course. But when a broker passes their exam, they have to have the initial 120. When they pass the exam, they have to have an additional 120 within 3 years. This course is what they're proposing, that they have a package of 7 parts that equals the 120 additional hours that you need within the 3 years to become a full-fledged broker. And I've reviewed these parts, and I presented it last time, but it was represented and continued today because there was concern if part of those, if an individual attendee, say, completed parts 1 and 2 but didn't do the rest, would they get full credit? Well, I spoke with Mr. Gray, the Kentucky-Tennessee Real Estate College contact, and he said, no, it's all or nothing, that they either get the 120 total or they don't get anything. And but he presented it to me in a way that I understood even better. But it basically, and it has been adopted, I want to say, by the Kentucky Real Estate Commission. So they have their own, it's not the same, but it's very similar to ours. They don't have as many hours as we do, but they have adopted this same course. But basically, it will cut down on confusion because we in the staff will constantly get phone calls from folks who have completed a number of hours of their, and they can choose now between any of our providers to get the 120. But with this one course, then it's all or nothing and it's done. So that would at least, and as Mr. Gray was proposing, it helps to cut down on some of the confusion. And as a person who's trying to get their broker license, how many hours have they gotten and when did they get it and so on, and thus they call the commission to find that out. Well, so I see the efficacy in that, and I think it would be a good course. However, it is the commission's approval that we're seeking. If it is certainly up to you, but it does look like it meets the muster of the rules and the regs.
Mr. Diaz.
Mr. White, is it your sense that the student, when they purchase this package, would they be notified that it's an all or nothing deal? That if they don't complete the course, they lose their money and they don't get credit?
Yes.
Okay.
Mr. Wood.
Ready for a motion?
Yes, sir.
I'll make the motion that we approve this class.
Motion by Mr. Wood, seconded by Mr. Moffitt, that this course be approved per Education Director's recommendation. I had one quick question.
Yes, sir.
So they've got 3 hours to get the 120 hours. 3 years. 3 years to get the 120 hours.
Right.
But we're only approving this course in 2-year increments, right?
Well, this is a little bit different when you think about the broker has to complete 120 hours additional. So that's what this proposes to do within the 3-year time.
I agree with that, but they've got 3 years to do it, but the course is only approved for 2 years. So in fact, and sometimes it's less than 2 years depending on when
I
it is.
think it's only approved to the end of next year.
That is correct.
So it's about 12, 13 months we've approved this for.
They will have to renew the course in next September to get that additional time.
So do you have the sense, Ross, that let's say I got 90 of the 120, the course expires and it's renewed. Do I only have to take another 30 hours then to get the whole 120 hours of credit?
Yes, Mr. Chairman. 120 of the 7 sections they would have to complete.
I can actually do it over 3 years.
And it is.
If the course is still approved.
Right. And keeping in mind it is an internet course.
I complicate the issue or make it simpler?
I think it should make it simpler.
All right, the motion on the floor is to accept the Education Director's recommendation and approve this course. If you're in favor of that motion, vote aye. Aye. If you're opposed, vote no. That motion passes. What else, Mr. White?
Thank you, Mr. Chair. Commission, nothing else in my report today.
All right, it's time to get some attorneys up here.
Oh, wait, I was going to give it one update and allow you to elaborate. We did reach out to North Carolina after the last meeting in regards to the surveys that they are doing. And so we found out a couple answers. I think it could be good probably to float it to all states to see what they do. But North Carolina does do surveys after licensees take their courses, and they answer questions on the course and the instructor that gave the course. They get generally around a 10% response. They currently do not do any credit for completing the survey. And then if they receive consistent negative feedback, then they do investigate the course or instructor via their complaint process. Do you have anything to add from?
We've also asked them how would they go about enforcing or auditing as far as the instructors to show that they're providing the right teaching skills and so forth. And the answer was that they don't have currently, they described it as bandwidth to do so, but they don't have the resources either, it sounds like. But hoping that they will someday in the near future. But she was very detailed in her response to the survey that goes out after the attendee has turned in their hours, or after the providers turned in the attendees' hours. They have the attendees' email addresses, so they send out these surveys, which it sounds like a good idea, and I think Director Maxwell and myself were just talking about going forward with that as we've got something coming. She can best describe, I think, but it's called Broker Core?
CE Broker, and it does have the capability to send out a survey. So.
Ms. Taylor.
What happens when they...
Up to the microphone, please.
What happens if they get the report back from the people that take the course that has a lot of negatives? What do? They
open a complaint and they review it that way. They investigate it further.
Right. So when they investigate it further, if they find the same thing, what do they say? Okay, this guy can't teach anymore. This course can't happen. What happens?
We can follow up, and I think if we wanted to implement something, we would obviously have to nail out the process of what that would look like. But I think that they probably include all the feedback from the survey in the complaint and then send that to the school or the instructor, allow them to respond. I don't know if they potentially sit in on the course or sit in on the instructors. We can find out more of those details as to what their process looks like. I'm just sort of guessing.
Well, I know there used to be something where people would, somebody, the association, something that would sit down on the course and give their opinion of how the course was taught. That doesn't seem to happen anymore. And there were a lot of people, not a lot, but there was some movement against some of the instructors or the content of the classes. And we don't audit anything anymore, correct?
Currently, we do not.
F.
Mr. White, when after the courses are approved, obviously, do we have some kind of goals or objectives that are part of the coursework that we could use as a metric when evaluating instructors?
Since the instructors are autonomous from the providers, they teach the course, but there's really not, at this point, you gather the information on the course from the provider, you gather the information about the instructor from the instructor, but there's not a linkage there. There needs to be more of a nexus, I think, maybe something to discuss going forward, but we really don't have that metric.
I think, that's going to have to be part of the conversation as we go forward.
Bobby.
I really like this idea of sending out the survey. I mean, and if you can do it without having to give CE credit, I mean, why not try that? I mean, and we've got some resources. If we need to spend some money to do that, let's do this. I mean, I think that would be a great tool for like when an instructor comes up for renewal at the end of 2020. I mean, and if you've got some material right there in front of you showing that students have had problems with this instructor, I think that gives you a great opportunity to have a conversation with them and maybe not renew them.
I agree.
I think that's awesome. I mean, and to go back to what I think Jeff was asking the question about, a lot of places I teach, it's an association of realtors, and they have their own evaluations now, and they're doing it primarily to see if they want to ask the instructor to come back. I mean, that's what they're looking for. But I like this. I mean, it sure does. I think it makes us something unique in our state.
Thank you. I think with CE Broker, and it's a project that's in process now. It actually has that capability to send out those requests for survey. So that seems like it's just falling into our lap. But
perfect.
Other comments? Ms. Maxwell, anything else education related?
Oh,
All right. Let's move to the consent agenda. Ask Ms. Bridges and Ms. Downey to come forward. So for Mr. Bridges and Ms. Torbett's information, legal department processes sometimes close to 100 complaints a month. And they can take a percentage of those complaints and put them into a category that these are obviously cases that should be dismissed. And so we have cases in two packages. One's the consent agenda, which we're about to get to. And in each case, legal has made a decision that the cases have no merit and should be dismissed. So we ask legal to read into the record the case number, but before we vote, we check with commissioners to see if commissioners want any of those cases pulled out so we can have further discussion. So eventually we will take one vote to approve dismissal of a whole lot of these cases, but there may be a handful or more that commission wants to discuss. So Ms. Bridges and Ms. Downey, Kelsey, and Kristen, left to right, have been assigned cases, and we'll hear from both of them at this time. All right, Ms. Bridges, would you read cases 1 through 31 into the record?
Yes. All right, number 1 is 2019-045901. Number 2 is 2019-046191. 3 is 2019-046231. Number 4, 2019-047151. Number 5 is 2019-047371. Number 6, 2019-049031. Number 7, 2019-049051. 8 is 2019-050361. Number 9, 2019-050231. Number 10, 2019-050581. 11 is 2019-051291. 12 is 2019-051791. 13, 2019-052221. 14 is 2019-052321. 15, 2019-052771. 16 is 2019-052211. 17 is 2019-053201. 18, 2019-054151. 19 is 2019-054281. 20, 2019-054891. 21 is 2019-055391. 22 is 2019-056001. 23 is 2019-056241. 24, 2019-056461. 25 is 2019-056701. 26 is 2019-056431. 27, 2019-055281. 28, 2019-056751. 29, 2019-057171. 30 is 2019-057881. and 31 is 2019-057321.
Thank you, Commissioners. The cases you want pulled out? All right, I just one. It's a minor point, but let's take number 15 out. And with that said, is there a motion to approve council's recommendation to dismiss cases 1 through 31 with the exception of 15?
So moved.
Second.
Motion by Mr. Diaz, seconded by Mr. Wood. Discussion. All right, let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. On number 15, Kelsey, this is a Craigslist deal. You know how Consumer Affairs likes to send us stuff?
Right.
Why don't we want to send this to them?
You know, we can. I'll gladly do that. The only reason I didn't make that recommendation is just because I think it's unlikely that they're going to be able to find who this person is.
They send us stuff that's unlikely that we'll do anything
That's
with.
true. That's true. I'll happily
Is there a
shoot
motion,
it over to
is there a
them.
motion to send 15 on to Consumer Affairs?
Motion to refer to Consumer Affairs.
Second.
Motion by Mr. Diaz, seconded by Mr. Wood, that case number 15, referenced as number 15, be forwarded to Consumer Affairs. Those in favor of the discussion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Dang, Kelsey, that was you pretty lucky.
I know. Let's do that every time.
I wonder how Kristen's going to do here at this point. All right, Kristen, if you'll read in 32 through 59.
Sure. 32, 2019, 045981. 33, 2019, 048991. 34, 2019, 049311. 35, 2019, 050431. 36, 2019, 050471. 37, 2019, 050451. 38, 2019, 051131. 39, 2019, 051331. 40, 2019, 051371. 41, 2019, 050771. 42, 2019, 051601. 43, 2019, 051921. Sorry. 44, 2019, 052001. 45, 2019, 053021. 46, 2019, 054211. 47, 2019, 054361. 48, 2019, 054561. 49, 2019, 054721. 50, 2019, 056301. 51, 2019, 056851. 52, 2019, 056621. 53, 2019, 057221. 54, 2019, 058471. 55, 2019, 058641. 56, 2019, 058911. 57, 2019, 059231. 58, 2019, 059921. And 59, 2019, 059551.
All right, Commissioners.
59.
Good.
34, 35, 36, 37, 38.
Say it again, 35 through 38.
34 through 38.
34.
And then 53, 55.
No such luck, Ms. Downey.
No such luck.
Other commissioners?
Fontaine at 50.
All right. Is there a motion to approve council's recommendation and dismiss cases 32 through 59 with the exception of cases 34, 35, 36, 37, 53, 55, 57, and 59?
And 38.
Did I miss 38? I'm sorry. That's right.
So moved.
Motion by Mr. Diaz, seconded by Mr. Moffitt. The motion is to dismiss the balance of the cases per council's recommendation. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimous. Mr. Wood, number 34.
Okay, on 34, I guess in the first large paragraph, it talks about, it says, complainant alleges that there were only 2 days left for bidding, so complainant contacted a different listing agent?
I believe this one was a situation where the complainant was dealing with someone that I don't think they particularly liked. So they went and looked for someone else to help them. And then once they had someone else
But
to
it wasn't another listing agent.
No, I think it was just the complainant, I don't think really understood what they were saying in the complaint. But I think what happened was they were talking to someone who was probably maybe in an administrative role and not particularly listed as the listing agent. And so they went and got someone else to help them with trying to purchase this home.
So it wasn't really a listing agent, it was just maybe an agent to maybe could serve as a buyer's agent.
Right, right.
Okay, let me drop down to the next paragraph. And as I'm on my sheet, it's right near the very bottom. It says, respondent alleges that they then returned the respondent's call.
I'm sorry, where are you?
Well, I'm on page 21. Is that at the bottom? So it's basically the third paragraph, but it's right at the bottom. Do you see the paragraph?
Oh, okay. Let me read it.
Okay.
That should be respondent alleges that they then returned the complainant's call.
Okay.
Sorry.
And then as I continue on in that sentence, and it says, after the second text, and informed complainant that complainant would be viewing the property with a different agent.
Uh-huh.
So the complainant. So in English, they talked to the complainant, and the complainant just said, I got another agent. Is that what happened?
Basically.
Okay.
Sorry, I tried to go back out and take out a bunch of the complainants and respondents and add they, but I missed a few.
Okay.
Sorry.
All right. All right. I'm going to make the motion. We agree with the council's recommendation, dismiss.
Second.
Motion by Mr. Wood, second by Mr. Diaz, that case number 34 be dismissed per council's recommendation. Discussion. All those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. 35.
35. Okay. I think 35 was the one.
It relates to 36, 37.
That's probably why I had all those
Yeah,
together.
36 and 37.
Okay. So this was maybe where somebody had their real estate license, but maybe they weren't using the real estate license in this transaction. There was in part of the complaint, I think it said that they didn't use a personal interest disclosure, or didn't even disclose that they were a licensee. But I never saw where the respondent answered that. Did they answer that?
So the number 35 was against the buyer who's also a licensee. They did have an agent who was representing them in the transaction, and they did report that they provided the property interest disclosure, and they signed it. But what I think happened when they disclosed it to the seller's agent didn't tell them, the sellers, right away. So once they were told, they were under the impression that the buyer licensee just waited to the last minute to disclose it. But that's not what it appears from the documents that I was provided. It just seems like maybe there was a lapse.
You just think the listing agent didn't disclose it to the seller?
Not right away. They disclosed it, but just not at the same time that the buyer gave them the disclosure, which is why I recommended the dismissal, because the obligation is just for them to provide the disclosure, not for them to communicate directly with the seller.
Okay. If you understand it that way, that's good. Then I'll make the recommendation. We agree with the council's recommendation to dismiss.
Second.
35, 36, and 37.
Let me make sure. Yes, I'm good with all those. So it's 35, 36, was it 37 is part of that too? Yes, it is.
Yes.
Let's do that.
I'll second.
Okay, so the motion on the floor is to accept council's recommendation and dismiss cases 35, 36, and 37. Discussion. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. Number 38, Bobby, the motion passes unanimously.
38, I'm not, at the second paragraph, it says complainant alleges a respondent behaved in an unethical manner when respondent signed a recruiting agreement.
Oh, this doesn't have anything to do with real estate.
Thank you.
Okay.
That's why I recommended dismissal. This is
Okay.
something about them trying to get people. This person's not it just doesn't have anything to do with real estate.
It sounds to me like it's a
On the world did
team
it get
member
to us?
perhaps recruiting somebody to come work in their team.
Exactly. And I don't even think this person who filed the complaint is a licensee or anything. Like, I think it's just them being upset that they got let go because they didn't fulfill an obligation to recruit individuals that this broker was seeking.
Okay. I'll make recommendation to accept council's recommendation to dismiss.
Second.
Motion on the floor is to dismiss number 38. Motion, Mr. Diaz seconded it. Further discussion? Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 53.
I'm trying to figure out, 'cause I was trying to, I've got myself a note here, were they doing unlicensed activity?
Oh, okay. If you have a particular question, I'm happy to answer, but just, I know this one because I spoke with Denard about it. And from what it appears, this person had has a real estate license, but before they got their real estate license, they worked as a property manager. They didn't let go of that job as the property manager, which I assume is like their primary job. So they were managing a few rental properties for just a private owner. And her broker, the respondent's broker was under the impression that the respondent was working under their license to do this property management, which wasn't the case. This respondent was just collecting checks and doing what would actually fall up under the exemption for property management and wouldn't necessarily require her to have a broker's license to conduct that kind of activity. So I think there's just some miscommunication, and this respondent, I think, just kind of got a little bit afraid because they thought they did something wrong because their broker told them they did something wrong. But
Okay.
this type of activity is...
But you're convinced what they were doing did not require a license then?
No, I don't believe it did. Just based on the description of what she was, or what the respondent was doing, it would fall up under an exemption.
Okay. Then I'll accept council's recommendation to dismiss.
Second.
Mr. Wood, seconded by Mr. Diaz, that case number 53 be dismissed per council's recommendation. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Your last one, Bobby, 55.
I think they take over a property management company. Is that what this one was?
Right. So this respondent doesn't have a license anymore. They let it go quite a while ago and just does exclusively property management. So they took over a property management company and just assumed the duties. But I never got a response from the respondent to know kind of what their position was regarding this issue. And they're not under any duty to respond since they're not licensed. But just doing some investigating on my own, it appears that company is actually just a property management company. It doesn't appear that they're doing any sort of buying or selling as far as real estate. So I just went off of what I could find since they didn't respond. But
if they're a true property management company, don't they have to be licensed?
well, they would fall up under an exemption if they only do property management and is just them collecting monies and maybe inspecting the property. Now, if they're doing something beyond that, then that's a different conversation. But in this instance, just from what I saw from my research, it doesn't appear that there's anything more going on other than them just receiving monies and inspecting the properties.
I'm like, how can they be a real property management company and not do more than just collect rent?
Well, there's that exemption in here. Hold on, let me find it.
I'm not talking about the law. I'm talking about from real life. I mean, if they're going to be a property management company.
Well, I mean, there are other things that you can, that the statute says that you can do as a property manager, but as far as entering into real estate transactions, they're not drawing up the lease agreement and having these people enter into them and finding locations for them to rent houses. They're literally just collecting the money from the tenants and making sure that the properties are looking nice and up to date and putting in any tickets for any repairs that need to be made, things like that. But not in the sense of being an actual real estate broker where you're showing properties and trying to find properties for people and entering into these agreements with other brokers.
So who's drawing up their leases?
I'm not sure who's doing it in every situation, but it's not the property manager who's doing it. It's probably a leasing agent who is licensed, but not a property manager. And like I said, I didn't get a response from this respondent, and they're not obligated to respond, but this is just research that I've done and information that is available to me in order for me to be able to make this recommendation. So this is all that I have to go off of, so that's my recommendation.
I also kind of look at, too, if they were not guilty, why didn't they respond?
Well, they don't have to because they're not licensed, so they don't have to respond, unfortunately. But I mean, if it was me, I probably would feel like it's better to just get my side out, but it's not me, so I can't make people do anything that they don't want to do.
I'm going to make a motion, try to encourage them. I'm going to make a motion, $1,000 civil penalty for unlicensed activity.
All right, is there a second to Mr. Wood's motion? Second by Ms. Taylor. All right, so the motion, if passed, would offer this property management. Is it a company? Should we describe it as a property management company?
Yes, that would be appropriate to say. And I mean, with this, obviously, we'll send out the letter and the consent order, and a lot of times when we do that, it does get a response back and provide us with some more details. So, I mean, I guess we could just see what happens.
I think it would be good because then they can justify why they should be exempt.
Okay.
All right, so, well, we haven't passed it yet. Your recommendation may stand.
Go ahead.
All right, the motion, if passed, would offer this entity a $1,000 civil penalty for practicing real estate without a license. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. All right, thank you, Mr. Wood. Now, Ms. Taylor, number 57.
Wood can help me on, because you had the same one, didn't you?
I did not.
You did not? Oh, okay, I thought you did.
All yours.
I thought by you. Okay. Well, I just feel like the respondent
Step up to the microphone.
The respondent didn't do their full job. If the respondent knew that the taxes had not been paid, that they were delinquent, and they did not make sure with the closing attorney that that was part of the paperwork at the end, I think they were delinquent in their faults. You know, I lose words sometimes. I don't think they were doing their job. That's what I say. And that they didn't seem to ever, it seemed like they didn't go after it or didn't try to help out their person.
Okay, so what's your pleasure, Ms. Taylor?
And Fontaine, this is kind of what my thinking was, because the way I looked at it, maybe somebody, when they did their search, title company did their search, they missed these taxes. And to me, that's why the title insurance has errors and omissions insurance.
Well,
and I kind of figured this was their problem, not necessarily the real estate agent.
Well, wouldn't you, though, if you were a real estate agent? My thought is, if I were a real estate agent, this happened to my client that I sold the house to, I would get in there and help them out. I mean, that's what I'm saying. Especially if they knew they were delinquent in the first place, I would certainly make sure that my closing attorney that I used would say, be sure this is in that thing, because there's some delinquent taxes we need to find. That's where I'm coming from.
So this complaint filed against a real estate firm. So do you want to make a recommendation or a motion?
I do. Is it the firm type of, okay. A reasonable skill and care, can we do that? What can we do here? You all help me out.
I generally take the position we can do whatever we want to, so. What do you want to do? And we'll see how it flies.
Reasonable scare and care and education. That's what I want.
Want to attach a civil penalty?
Yes. Well, civil penalty of, I'll do $500 in this case.
Dang.
How about that? I'm really feeling good today.
Add chocolate.
All right.
So there's a motion made by Ms. Taylor that if I can get a second to offer of a civil penalty of $500 for failure to use reasonable skill and care.
What would be the proper course, Bobby?
You got a firm. This is against a company.
Oh,
so
okay. Well, I don't know. Okay. Okay. No. Okay.
That required a whole firm.
Dismiss would be proper.
I tell you, I was trying to catch up so hard. I missed the whole thing.
If I get a second to Ms. Taylor's motion. Mr. Diaz seconds her motion, so it's properly on the floor. Now discussion on the motion. Again, let me repeat the motion. If it passes, we'll offer this real estate firm the opportunity to settle this case by agreeing to pay a $500 civil penalty. That's the motion. Hey, Caitlin, let's do a roll call on this. Are you all ready to vote?
I'll just say, I still think it's the responsibility of the title company. That's what they got paid to do. I mean, so I think I would vote against it. I just think it's the title company's problem.
Okay.
Well, we'll see how the vote goes. Okay. We just need to do one of these a month or so.
Okay.
Practice.
Commissioner Joe Begley.
Hey.
Commissioner Jeff Diaz.
Aye.
Commissioner Rick Douglas.
Oh.
Commissioner John Moffitt.
No.
Commissioner Fontaine Taylor.
Aye.
Commissioner Stacy Torbett. Commissioner Bobby Wood.
No.
Chairman John Grease.
No.
The noes have it.
All right, the motion fails. Is there another motion?
Make the motion to dismiss.
Second.
Motion by Mr. Wood, seconded by Mr. Douglas. This complaint be dismissed per council's recommendation. Discussion. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Thank you, Ms. Taylor. Now number 59.
Well, I don't know. This is long, and I hadn't been able to read it over again in that short time, and I'm sorry I didn't write enough notes on it.
Take your
But it
time.
seemed like there's a bunch of things in here that the respondent being a real estate licensee, the house was had the wrong square footage, had the wrong number of bathrooms, had the wrong age. There was so much that's in here that I certainly don't think this should be dismissed. I think there should be something done. I understand the people inherited the house, but still there's some responsibility on the person that listed the house to get at least one piece of it right.
So I'm more sympathetic to your argument on this one. Do you have a motion that you'd like to make?
Well, I make the motion that we fine them
Offer them a civil penalty. We don't fine.
and
And anything, any coursework or anything?
This, well, all right, Bobby, tell me the course.
I would probably say, I'd probably do a contracts course, a 4-hour contracts course.
Contracts
Motion made
course within 180 days and not to count as ongoing education.
Motion made by Ms. Taylor, if I can get a second, and it passes, would offer this licensee a civil penalty of $1,000 with the requirement that they complete a 4-hour contract course within 180 days that would not apply to their required continuing education.
Second.
Second by Mr. Diaz. Okay, the motion is properly on the floor. Mr. Wood.
If I remember, I think it was a partially finished home. Had been working on it, and I think what kind of got the conversation going was the ductwork ran upstairs, but then later I found that it talked about that there was window units in it. I mean, or at least in one of the rooms up there. So I just think like the square footage conversation, because the house was just, it wasn't completely done, lead yourself open to interpretation of what was going to be finished or not finished. And so that's because at first that was my big hang up, was the square footage. But when you got a partially finished house, you don't always know what people are going to finish or not finish.
Well, the square footage, and usually that is a big bother, but now that was not the biggest thing in here. It was 3 bedrooms and what was it, how many baths? 3 bedrooms and 3 baths, and it turned out to be 1 bedroom and 1 bath, and it was was 8 years. It was built 8 years ago. You know, the time frame. There was so many inconsistencies in here throughout the whole thing that it's just a mess, as far as I'm concerned.
You want to know what caught my attention, Fontaine? And this is not the only case that's occurred this month but the house was well over an hour away from the guy that lived, and he didn't see, he didn't want to, why did you take the listing if you can't go measure it? And to me, that's, I lost all sympathy for the fellow or lady. Okay, so the motion is on the floor. Brianna. Wait a minute, Brianna. Come back here just for a minute. Let's vote on this, and we'll. Any further discussion? Everybody understand the motion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. All right, Ms. Womack.
I did hear one.
Have you met our new commissioners? Well, walk up here real quick and meet them. How would you describe, Caitlin, how would you describe Brianna's position?
She's the administrative manager.
Chief Administrative Manager.
She's awesome.
Yeah.
Almost got away, Brianna.
I know, she's such a shy.
No, you almost got away.
Good to see you. Thanks for coming down.
Chairman Grease.
Yes.
We need to discuss number 55 again, previously. So we're doing a civil penalty for $1,000 for unlicensed activity. We can't fine or give a civil penalty to someone that is unlicensed for not responding to a complaint. We can't use a civil penalty as a means to elicit a complaint. They're not required to do so under the statute, and I would like the commission to reconsider using that as a means to something that is not required, as it may appear anti-competitive.
So to be clear, I think the motion, as I recall, was for unlicensed activity.
That's correct.
Not for failure to respond.
Yes, it's for unlicensed activity, but during the discussion, there was discussion about wanting a response after sending a consent order so we could get additional information.
Well, my guess is, and I'm not trying to, anybody else can speak to that, but, you know, we have several cases again this month where there's reconsideration because we get new information. And so if we send this out and they want to say, hey, here's the information, why we don't think we should pay it, that's maybe what we're trying to get.
But based on the information that we have right now, you think there is enough, does the commission think there's enough information for unlicensed activity?
So you gotta-
That's the threshold question for right now. We can't do a civil penalty in a consent order and require somebody to give us more information to then dismiss it. That's not how it works.
They don't have to respond. And apparently, the commission thought that we had enough evidence, or we wouldn't have voted that way.
Well, I'm responding to the discussion that was on the record previously about it, and to me, that is something of concern based on what's the discussion of this.
Well, I think that we did determine that there was enough evidence that there was unlicensed activity, and the statement was just simply made that if they feel that it wasn't unlicensed activity, then they can appeal, give a response. Otherwise, they're fined $1,000. Is that, am I stating that correctly? Bobby, was that you that made that motion?
I'm just disappointed that we're taking one comment out of the whole conversation, and you're trying to build a case off of one comment. I just
Well,
don't
the
think
reason
that's
I'm
fair.
taking that one comment is because we have anti-competitive things that we need to consider, and my job as your attorney is to make sure that you do not get into legal trouble for it. So therefore, having more additional conversation on the record only helps you.
So I think it was a sense, I appreciate the advice, but I think it's a sense of this commission that we had a pretty good discussion on whether it was licensed or unlicensed activity. I mean, I got it. Yes, Ms. Torvin.
So your issue is just with the comment on the record that we're fining them to get them to respond. Is that the problem?
That's the issue that I have with that statement on the record, because it is an anti-competitive statement, because as an unlicensed individual, there is absolutely no duty to respond. And if we were to use civil penalties and consent orders as a method to elicit a response from an individual, that is improper usage.
So you don't have issue with the civil penalty. It's just the phrasing leading up to the civil
I
penalty.
wanted to make sure that that is not what we were doing the civil penalty for, that we actually believe that there is unlicensed activity in this instant. So I needed further clarification for when this is reviewed ultimately later on the record, so we don't have to reconsider it or pull the decision.
I think I'm the guilty party in those comments. I think I was just trying to make sure that we understood on the record that if the respondent disagreed with our consent order, that they had the opportunity to appeal.
Okay, that's fine. I just needed more discussion based on that. I'm trying to help you here.
Thank you.
All right. We are done, in the opinion of the chair, with the consent agenda. Anybody need a break before we go on to legal? Let's do it then. Kelsey, number one.
All right. Okay, number one on the legal report is 2019-045891. Complainant was the buyer and respondent was the designated listing agent. Complainant was also represented by their own agent in the transaction. Complainant accuses the property sellers of fraud and alleges respondent knowingly aided their client in carrying out the scheme. The parties entered into an as-is purchase and sale agreement which specified that the washer and dryer were to remain on the property. Closing was scheduled for April 26, 2019, with a final inspection to occur on the 25th. While at the final inspection, complainant observed that the washer and dryer had been removed. Complainant notified their agent that they would not sign off on the purchase without assurances that the units would be returned or that they would be financially compensated. Complainant states the sellers agreed to return the units and they moved forward with the closing. However, they did not immediately move in because of renovations. Nearly 3 weeks later, complainant learned from their contractor that the washer and dryer were completely inoperable, and upon further inspection, they noticed that the units did not match the ones that were removed. Complainant states the sellers knowingly replaced the original units with cheaper models, and that respondent assisted them in the fraud by delivering the cheaper units and trying to pass them off as the originals. In their answer to the complaint, respondent stated that during the packing and moving process, the sellers forgot that the units were supposed to stay and had them removed from the property. Respondent stated that the sellers initially offered to compensate complainant in the amount of $500, but complainant would not accept less than $1,000. The seller thought $1,000 was excessive for a 5-year-old non-matching set, so they instead suggested purchasing a replacement set.
Respondent told them that it would have to be of equal or greater value. The sellers purchased a like new set with a 30-day warranty, and respondent agreed to help out by delivering it to the property. When they learned from complainant that the machines weren't working, respondent offered to arrange for a repairman to inspect and repair or replace the units, but complainant refused. There's no evidence that respondent aided or was complicit in any fraud or scheme. However, it appears that the parties would have been better off had they reached a specific agreement on the terms of the washer and dryer replacements and documented it in writing. Because respondent has no prior disciplinary history, counsel recommends a letter of warning. And that would be a letter of warning with regard to reasonable skill and care under 6213-403.
Council's recommendation.
Motion by Mr. Diaz to accept council's recommendation. Is there a second?
Second.
Second by Mr. Begley. Mr. Wood.
You can just sense me, can't you?
I can tell.
I guess my concern was I really think this is an issue between the buyer and seller. I mean, I really believe the seller did something wrong. But outside the agent standing there and go, that goes, that doesn't go, and it looks like they tried to mediate the problem, and then maybe the seller still didn't act appropriately. I don't know that what else the agent could have done. I mean,
I agree that this is an issue between the buyer and the seller. The reason I was leaning towards letter of warning is because to me this looks like they amended the purchase and sale agreement and nobody put it in writing, nobody signed it. And I don't know, I guess I feel like maybe an agent should know that if you're going to make amendments to the purchase document, those need to be in writing. But I agree with you that this is really an issue between the buyer and the seller. So I could go both ways.
Mr. Wood, you've got the floor.
I'd like to amend the motion to dismiss.
We'll make it a substitute motion.
Thank you.
To dismiss.
Okay.
To dismiss. Is there a second to that motion? Got a second by Ms. Taylor. Okay, now the motion on the floor is to dismiss this complaint. Discussion on that motion. All right, if this motion passes, we're done with this case and we'll move to the next. If the motion fails, we'll go back to the original motion, which was made by Mr. Diaz to accept council's recommendation. All right, are you ready to vote? Let's do it. Those in favor of the substitute motion to dismiss this case, please vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number two.
All right, number 2 is 2019-045971. Complainant is a home improvement contractor who was hired to work on a home that was listed by respondent, a licensed broker. Complainant alleges they were never compensated for their work and claims respondent is responsible as they were the one who actually hired complainant as opposed to the property buyer or seller. According to both parties, respondent contacted complainant to perform work on the property pursuant to the buyer's request, but note respondent was representing the seller. Complainant agreed and began the work. After the project was completed and 1 day prior to closing, the buyer did their final inspection and apparently had issues with the work. Respondent contacted complainant to let them know that the buyer wanted to escrow $5,000 from the sellers and select their own contractor to do additional repairs. Respondent claimed complainant agreed to waive the cost of the repairs. I think I may have left out a paragraph, but essentially there's just a lot of back and forth about did they agree to forego their fee or did they not? This appears to be an example of a real estate broker taking on more duties than were necessary to effectively represent their client in the transaction. Council recommends a letter of instruction.
Commissioners?
I'll make the motion to accept council's recommendation.
Perfect. I'd like to get something on the floor. Is there a second?
I'll second.
Thank you, Ms. Taylor. The motion properly made would accept council's recommendation if passed. Discussion.
So did the broker, did they actually help get the contractor, or did they actually do the work?
It sounds like the broker helped get the contractor, but now there is a dispute as to who owes the contractor money. Who actually hired the contractor? The contractor says the broker hired.
So it's the contractor that's filed the complaint over the money.
Right.
So it really doesn't have to do with their real estate license.
It doesn't, but we've seen over the past couple of meetings, this issue has come up a lot where agents are agreeing, or it seems like agents are getting involved a little too much. They're agreeing to hire schedule inspectors and so on and so forth. And as we've seen, that usually tends to just get them in trouble. So that's why in this case, I felt like maybe a letter of instruction would be appropriate, just telling them, stick to the brokering and leave the rest to the buyer and the seller.
I would think a general contractor would know who's going to pay him before he swings a hammer. I think, rather than saying, okay, I'll do it, not knowing where his check's coming from.
Mm-hmm.
A lot of these contractors, honestly, they're handymen. They do a lot of this work on the side, and a real estate agent might call and say, "Hey, I've got a client that needs some work done." I think a letter of instruction would be wise, in my opinion, just to let this agent know, hey, from now on, get the seller or the buyer, whoever's going to pay the contractor. Here's some information on who you can call. You call them and hire them. And because I can understand how a contractor might think that the agent hired them.
I can understand a lot of agents trying to be super agent and
Sure,
speaking on behalf and working for the seller when they have maybe authority but nothing in writing to do it themselves.
Right.
But I do think sometimes we as a commission get drug into it, and the agent gets drug into it because it's easier for this contractor to file a complaint with us than it is to go and get an attorney and do what they really should do and go after, or to file a lien against the property and to do all these things, but instead they sling a complaint to try to see if they can shake somebody loose. So
I
talking
agree.
about a $1,200, or whatever. This was $5,000.
$5,000, yeah.
It probably cost them, 3/4 of that to hire an attorney. So,
and that's why we're hearing about it.
Ms. Bridges, do we have any sense if the contractor himself was a licensed general contractor in the state of Tennessee? Oh, thank you.
So the motion still on the floor would be to accept council's recommendation. Further discussion? Bobby, come on, say what you're thinking.
I want to offer a substitute motion to dismiss.
Mr. Wood has offered a substitute motion that if he can get a second and passed, would dismiss this case. Is there a second? Last call. Is there a second? Chair rules that motion failed for lack of a second. We're back to the original motion, which is to accept council's recommendation. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 3, Kelsey, could you just give us a quick summary of what's going on here?
Yes, I just have to read it really quick. Okay.
The neighbor was telling them something was wrong with the house when they bought it, after they bought it.
But the bottom line is the complaint's against the wrong person.
Complaints against the wrong person.
So your recommendation is to dismiss that complaint and open a complaint against
the complainants, against the listing agent who marketed the property, not the complainant's agent.
Motion to accept council's recommendation.
Second.
Motion by Mr. Diaz, seconded by Mr. Douglas. The council's recommendation be adopted. The complaint against this real estate firm be dropped, and instead a complaint be opened against so I'm clear on this, is the buyer's agent?
The seller's agent.
The seller's agent.
Yes, because they're alleging that the adverse facts weren't disclosed.
Okay, got it. Discussion. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 4.
Okay, number 4 is 2019-055771. Complainant was an interested buyer and respondent was the seller's listing agent. Complainant alleges respondent neglected to present complainant's offer to the seller. In support of their claims, complainant states the property was listed on May 23rd. They submitted a full asking price offer through their agent the next day at 11:40 a.m. They included an earnest money check and a letter from their bank along with the offer. Their agent sent the offer to respondent via fax and email. After the listing agent informed them that their offer was rejected, complainant reached out to a representative for the seller who told them via email that their agent never communicated complainant's offer. Respondent stated that there was a 10-day hold on all offers. However, complainant alleges this was not disclosed on the listing. Respondent was out of the office during the 10-day hold period, and they were not aware that complainant's agent sent in an offer. Respondent states it was only after speaking with their client that they learned complainant's agent had faxed over an offer on May 24th. The offer that was accepted by respondent's client was submitted on June 3rd. Email records provided by complainant and respondent's answer support a finding that respondent violated 6213-433A2 which states that unless specifically waived by the client in writing, an agent must receive and promptly forward all offers to their client. Because respondent has no prior disciplinary history, counsel recommends a civil penalty of $500.
Good.
I like that. I think this is a big deal. I mean, a bigger deal than what, I think they got two issues. I mean, one, not submitting the offers is one problem. And then the other thing was not exercising reasonable skill and care. I mean, I never understand how agents forget to submit offers, but apparently this one did. And it also, it means, I don't know, it's not part of this, but it could have cost that seller money and could have cost them substantial money. And so that's why my motion would be that we have a $1,000 civil penalty for not submitting the offers on a timely basis, and $1,000 for not exercising reasonable skill and care.
You want to stop there?
No, and a 4-hour contracts class that they do not get CE credit for.
180 days.
Within 180 days.
Is there a second to Mr. Wood's motion?
Second.
Mr. Moffitt seconds the motion. So the motion, as the chair understands it, if passed, would offer this respondent a $2,000 civil penalty broken up into two parts of $1,000 each, failure to present an offer, and second, reasonable skill and care. In addition, the respondent would agree to take a 4-hour contracts course within 180 days of signing the consent agreement, and those 4 hours would not apply to other continuing education requirements. Do I have it right, Bobby?
Exactly right.
And we've got a second. Mr. Moffitt, is that what you understood? All right, now discussion.
The only thing I can say is who in the world has faxed anything in the last 20 years? But other than that, it's fine.
But remember, you're the one that doesn't do online banking.
Among other things.
Commissioners, help me out. Is that practice of holding offers for 10 days, is that common? I've never heard of that.
Or is it common to say that you didn't get it because you're on vacation when you got emailed to you?
Well,
And faxed. It's date stamped, right?
but if you don't, usually if you don't present offers for a few days, you say to everyone, I'm not going to present the offers till 7 o'clock Sunday night, whatever the date is. That gives people time to do that, but just to arbitrarily withhold them, no, that's totally wrong.
So, as I understand it, your motion has Ms. Taylor's blessing. All right, Mr. Diaz, call for the question. It's non-debatable. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 5.
All right, number 5 is 2019-05-6971. Complainant alleges unlicensed activity. Respondent is a licensed real estate firm in a bordering state, but they are not licensed here. An attorney for respondent answered on their behalf. The attorney states one of their clients, or one of respondent's clients, requested they list the subject property and find a local licensed agent, that should say to assist respondent in the transaction. Respondent entered into a co-broker engagement agreement to retain and appoint a Tennessee agent to represent the client prior to accepting the listing. They argue this meets the requirements of Tennessee Code 6213-302, which provides that a licensed broker may pay a commission to a licensed broker of another state if the non-resident broker does not conduct any negotiations in this state. Counsel agrees that there is no issue under 6213-302, but notes that respondent still directed an advertisement for the Tennessee listing to at least one individual in this state. Because respondent is properly licensed in a neighboring state and has no prior disciplinary actions here, counsel recommends a letter of warning.
Motion to accept counsel's recommendation.
I'll second it.
Ms. Taylor seconds that motion. Excuse me. Discussion.
So they're licensed in another state, but they're marketing a property in this state, and they're not licensed to do that.
Yes, but I do want to stress, as far as I could tell, the marketing is only, they sent one email. Now, they may have sent it to a bunch of people, but I only have evidence of one email that went out advertising the listing.
You think the property was co-listed between two companies?
Yes.
So one of the companies wasn't licensed in Tennessee.
Right.
So is it hard to have a fiduciary relationship with that owner if you're not licensed in the state?
Well, the Act specifically provides, it specifically addresses this situation, and under 302, that line that was quoted, it does entertain the possibility that brokers are working with people out of state. Like I said, I don't think there's an issue there. I just want to caution them that our definition of brokering includes advertising, so they really just need to stay in their state. Yeah, stay in their lane.
Now, it seems to me there are brokers in Tennessee, when they advertise a property, send all kinds of information out of state to other companies, or other individuals.
They might.
Isn't that part of marketing?
Well, yes, but again, our definition of brokering includes marketing, includes advertisement. So regardless of what other people are doing, I think here they did technically engage in brokering, but it was one email, and it appears to me that they took the steps necessary to try and avoid unlicensed practice.
Hey, Joe, could I ask you a question? So you're up there, almost a border town. So a Virginia licensee has a friend in Tennessee. What does that licensee do as far as listing that friend's house?
Well, a lot of our firms
Move up to that microphone just a little bit.
A lot of our firms have Virginia and Tennessee license. So usually somebody in the office, they may refer it out or co-list it. But in this situation,
That's what I'm more familiar with, is the referring it out rather than co-listing it. 'Cause I can't ever remember me co-listing with somebody in another state. I'd always be referring it.
But it might just be a matter of semantics.
but if I referred something out and they sent me a copy of the listing and I sent it to a friend of mine via email somewhere else and said, hey, here's something you might be interested in, I don't know. It's kind of fuzzy to me.
I think the law is kind of fuzzy. I mean, we get questions, or I get questions all the time in commercial real estate about what somebody out of state can do in Tennessee.
Hire a Tennessee agent.
Well, the problem is the client is loyal to the agent. The agent knows how the client works. So, Mr. Diaz, this motion still is on the floor and seconded by Ms. Taylor, and it would be to accept council's recommendation.
Call the question.
Mr. Diaz is tired of talking about it. Anybody want to object to the call?
It would be. It might be a matter of semantics, but I think it would be good to know if this was a co-broker arrangement versus a referral agreement. So that's just my thought. Seems like it's a referral, and I wouldn't have a problem with the guy sending an email to somebody, hey, here's a property you might be interested in over in Tennessee.
All right, let's go with the motion. Unless there's further discussion, if you're in favor of the council's recommendation to send a letter of warning to this respondent, you'll vote aye. Please vote. I just thought I'd change it up. But if you're in favor of the motion, vote aye.
Aye.
If you're opposed, vote no. All right, the motion passes unanimously. Number 6.
Number 6 is 2019-057241. Complainant, a licensee, alleges unlicensed activity. Complainant claims that respondent enters into low sales price purchase agreements and then assigns the contract to a different buyer at a much higher cost. Complainant provided a screenshot of a listing allegedly made by respondent on Craigslist. The listing expressly states this is an assignment of the contract. Complainant states that they contracted to purchase the property on Craigslist and that they are scheduled to close next week. Respondent claims they have the legal right to assign the contract per the terms of the agreement and states that they have never held themselves out as licensee. Counsel agrees that respondent is allowed to assign and execute a contract. However, there is a concern that respondent may appear to be operating a real estate firm, intentionally or otherwise, as the listing states that it was made by respondent's last name, which is redacted, Properties. Counsel believes that the name of the business indicates that they are engaged in the real estate industry and could lead someone to assume that they are licensed, but does not necessarily think it constitutes holding out in and of itself. My recommendation is for a letter of warning.
I was just maybe investigating. There's so many of types of these things going on. So how in the world investigate?
Who owns the property, the individual or a company?
So ultimately what happened here was the respondent wound up purchasing the property. They were trying to assign the contract, but they never did, so they closed on it themselves.
And I would agree with the recommendation. If the respondent bought the property in his name, but then he was trying to advertise it as an assignment contract under the name of a business, then I certainly agree with the recommendation. But if he bought it in the company name, then he would have to advertise it. If the company is the owner, right, he would have to advertise it as whatever it is, properties. Would that not be correct?
No, I think that's an accurate statement, yes.
Need a motion?
Chairman?
Motion to accept council's recommendation.
Second.
Motion by Mr. Diaz, second by Mr. Douglas, that council's recommendation be adopted, and this respondent be sent a letter of warning. Discussion. All right, let's vote. Those in favor?
One more bit of discussion.
Sure.
Is a letter of warning or a letter of instruction best for this?
In the case of an unlicensed person, I don't think the distinction is, there's a very big distinction. Typically, a letter of warning is considered discipline, whereas a letter of instruction is, we don't really refer to it as discipline. A letter of instruction is private. It's not added to our disciplinary action report, whereas a letter of warning would be public discipline.
I would like to make a substitute motion that we give a letter of instruction.
Apparently, letter of warnings are also not on the disciplinary action report, but in terms of penalties and the scale, it goes letter of instruction is the good one or the best one, and next is letter of warning.
I'll stick with my
Letter of instruction. Second, I don't.
Second.
Ms. Taylor seconded the motion. So now that's the motion that's on the floor. If passed, we'd ask legal to send a letter of instruction to this respondent saying, I'm not sure what. Change the name of your company because
I'm not going to tell them to change the name of their company. I'm just going to say that this name, it sort of looks like it suggests that you may be a licensed firm, which you are not. So yeah, it's really just putting them on alert that more complaints might come, and if they do, the commission may have to take action.
in my opinion, so I'm going to vote no on the motion. An individual ought to be able to call his company whatever he wants to.
Oh, the commission has rules that state you can't call it necessarily whatever you want to.
That speaks for teams, right? It talks for teams.
That's true. Again, the definition of brokering includes someone that holds themselves out as a broker. I just think that this name is really skirting the line.
Mr. Chairman, my instruction, that when I say a letter of instruction, it was not to instruct them to change the name of the company. It was to instruct them that if you bought this in the name of the company, okay, then, I mean, because we don't know. We don't really know if there's a violation here, right? For certain, because, you know, you said, did you say for certain that he bought the property in his name personally?
Oh,
then
okay.
He advertised the property in the name of the company. And I think that's where the letter of instruction comes. Hey, if you bought this personally, you can have an assignment contract and you can advertise that, but it needs not be advertised in the name of a company because then it appears that you're practicing real estate without a license. Is that right?
I'm not sure under what name the property was purchased. I didn't get the impression that they're necessarily trying to, have two distinct entities. I don't think this is. I don't know. It was kind of I'm trying to think of the best
But
word.
what a letter of warning, wouldn't that be for a violation? I mean, we're softening it up. We're not going to fine them.
My recommendation is based upon the name of the company that they are advertising on Craigslist.
Okay, let me muddy the water. Okay, so let's assume they were trying to assign this contract and resell it before they closed on it, right? If they're not a C corp, wouldn't they had to have done that with a real estate agent?
No, in the case of assignments, pretty much anybody can do that.
But can't they? But if they're marketing it, don't they have to have a real estate agent to market it?
Not to market your own property.
Only if it's an LLC.
Well,
Only if it's not a C corp. Let's say this is a LLC. Wouldn't
It's
they
not,
have to? Okay, was it a C corp or a partnership or
sole proprietorship?
Oh,
You can call yourself anything you want to as a sole proprietorship, and you don't have to recommend.
And I think from a consumer's point of view, though, if I see a company and it's whatever it's named Properties,
He has properties.
Yeah.
I would assume that's
That-
a real estate firm.
so the name of the company is problematic, to say the least. So I think a letter of instruction saying, or a letter of warning, telling this person the name of your company is problematic, even though we can't force them to change it. Like Ms. Bridges said, other complaints might be forthcoming and force our hand.
All right, the motion, letter of instruction. Letter of instruction.
I'm going to withdraw it because I don't think anybody's really understanding what I mean by letter of instruction.
Oh, I know exactly. But you want legal to say what you just said.
Yeah, I guess so. I just don't. I don't have a problem with the name of the company. My only problem is did he buy it in the name of the company or did he buy it under his own name? And if he's advertising this contract, his assignment contract, it needs to be advertised accordingly, which entity he bought it in. If he bought it personally and he's advertising it under XYZ Properties, then I see a problem. And that's where the letter of instruction would come in, is just kind of just tell him, hey, be careful. This is what you need to make sure that you do. Maybe I'm off base here, but that's...
No, I mean, if he bought it in his personal capacity, he needs to do a for sale by owner kind of thing, rather than marketing it through his own company. Is that what you're saying?
That's kind of what I...
Spent a lot of time on
I know,
small
yeah.
issue. All right, there's a further discussion. I think we're ready to vote. Mr. Douglas's motion is to send a letter of instruction to this respondent talking about the need to be consistent, and in case there's an LLC involved in some of this transaction, what you can and can't do.
Well stated.
Roundabout. All right.
Is that clear enough, Ms. Know what you're writing?
It is. I can just say definitively there's not an LLC involved.
Yeah, I didn't think there was.
Yeah, so I guess I'm just not sure. I understand what you're saying, but I don't know where the commission would really be able.
I guess I'm asking them, why are we even
To
sending a
address
letter of
that.
warning?
Well, again, so my recommendation is based upon the name. I think the name is problematic. Yes.
That's my point.
I disagree with that.
I mean, you can have whatever name you want. The reason it's problematic is because he's advertising this assignment contract in the name of that company, right?
Yes, but the company is the individual and vice versa. There's no legal distinction. If you were to sue the company, you would be suing the individual.
I withdraw my motion and make a motion that we dismiss.
Or a second to that motion? Second. Okay, that's a substitute motion.
Yes, sir.
No, it's not. You withdrew your motion, so I'm okay with that. So the motion is to dismiss, made by Mr. Douglas, seconded by Mr. Wood. Discussion on that motion. Let's vote. Those in favor of the motion vote aye. Aye. Those opposed, no. That motion passes on a 7 aye, 1 no vote. Mr. Diaz votes no. Numbers 7 through 9. Kelsey, can we do those together?
Yes. Number 7 is 2018-072661. Number 8 is 2018-079561. And number 9 is 2019-004791. Those complaints are all against the same respondent, a licensed principal broker. Each complaint alleges respondent mismanaged their firm's accounts and escrow funds in the firm's possession. Due to the nature and volume of the complaints, counsel requested an audit of respondent's firm accounts. Respondent has been given numerous opportunities to respond to the audit request, but has thus far failed to provide any of the requested documents. Respondent failed to respond to the initial audit request, which was sent out in April of this year. Thereafter, an investigation and request for documentation was opened, but again, respondent declined to provide the records. Counsel reached out to respondent in August and spoke with them via telephone some weeks later to stress the importance of receiving the requested materials. And they stated that they had been in and out of the hospital, but they would attempt to get the records to commission staff later that week. Again, respondent failed to provide the records. So unfortunately, my recommendation is for a revocation for failure to respond to an audit request in violation of 6213-312D.
Motion to accept, counsel.
Second.
Motion by Mr. Diaz, seconded by Ms. Taylor, that council's recommendation be adopted and this principal broker's license be revoked. Now, Kelsey, in the past, we've had, they're not called emergency cases, but accelerated hearings to get it because there's a possibility that the licensee is a threat to the public. Does this rise to that?
I don't think it does because I don't have any evidence that they are actively brokering. It sounds like I do believe them that they've been in and out of the hospital. I don't think they're out there buying, selling, brokering properties actively, which would address the immediate harm component of a summary suspension.
Escrow fund. What about the escrow funds, though? If they have escrow funds and nobody's looking over it, what's going on?
Well, that's a good question. That's why we sent out the audit request. I mean, these complaints are fairly old. Let's see, number 7, was opened in October 2018. Number 8 was November 2018, and then number 9 was from January of this year.
And they haven't responded yet? I think there's a real...
They provided some answers, but they were not sufficient to address the allegations. So that's why we sent out the audit request, the investigator. I spoke to them.
Should we revoke their license? What's the time frame? Is that immediate?
It would probably, let's see, given the time of year it is, it would probably be January or February before the actual hearing took place, unless they agree to just surrender, but usually they don't.
Does this principal broker also hold the firm license?
I don't think they have I mean, they might. I didn't look to see.
Are there
if they
other
have a firm
agents
license.
at this firm?
According to the respondent, no.
Okay.
I don't think there are. I did pull up their license record at one point, and I didn't see anything. Any other agents?
No other agents. That's even better to let's go ahead and revoke it and get this done. Yeah.
Remember, if the motion is to revoke, that's just an offer to the licensee, and the licensee has to accept it. What I'm, don't take this personally, but what I'm concerned about is the third complaint was opened 10 months ago, and it's just now in front of us.
We've been trying to work with him or with them to get the records, but it seems to me that they were just stringing us along.
All right. Just generally speaking, don't take this personally, but these are the kind of issues that are important. When you got an escrow account that you can't audit, there's no telling what has gone on, and in the past we've seen some really bad things. So don't let those people string you along. Let's get it to us. All right, the motion is to accept council's recommendation and revoke this licensee's license. That's an offer to the licensee that he or she will have to accept. If they don't, then we'll have a formal hearing in fairly short order. You ready to vote? Let's do it. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 10.
Okay, so number 10 and number 11 are actually identical. Number 10 is over, I'll just read the summary.
Let's do.
2019-051781. This matter is related to complaint number 2018-082431, which the commission deferred in April 2019. The summary for that complaint is as follows. Complainant is the owner of a rental property and respondent is an affiliate broker with a licensed real estate and property management firm. Complainant alleges respondent specifically and the firm in general failed to adequately represent complainant's interest in the management of their property. Complainant notified respondent that they would terminate their management agreement after the current tenant's lease ended. Complainant claims that at the conclusion of the lease, respondent informed the tenants that they would receive their full security deposit back when there were multiple repairs that had to be completed, or sorry, I got lost. I'll just back up. Complainant claims that at the conclusion of the lease, respondent informed the tenants that they would receive their full security deposit back when there were multiple repairs that had to be completed, and states that respondent failed to provide complainant with the move-out inspection report and other documentation. A representative from the firm, but not respondent, conducted a move-out inspection at the end of the tenant's lease and found the property to be in an acceptable condition, save for one or two items which needed repair. Those items were photographed, documented in writing, and uploaded to the owner portal, made available online to complainant. Respondent notes that the owner portal provides complainant 24/7 access to all management agreements, lease documents, communications, maintenance requests, inspection reports, and other transaction materials. Complainant also performed an inspection and determined more repairs were needed than just those that were identified by the firm. According to respondent, complainant wanted to withhold more than what they and their managing broker felt was equitable, so with complainant's written approval, they deducted some costs for repairs that would be handled by the firm and delivered the remainder of the deposit to complainant so that complainant could make the final determination as to what amount, if any, would be returned to the tenants. A representative for the firm, a quote tenant specialist, advised the tenants that the deposit was being handed over to complainant. Respondent never personally interacted with the tenants. The reason we brought this one back in front of you all is because the only real issue seemed to be that the affiliate broker was handling the escrow funds. So we deferred it and then opened the same complaint against the principal broker to get more information. The principal broker pretty much just told us the same thing. They were the one that was managing the escrow account. I think with respect to this complaint and the one against the affiliate broker, both should be dismissed.
All right, Commissioners, is there a motion regarding cases 10 and 11?
I'll make the motion to accept council's recommendation about those.
Second.
I have a motion by Mr. Wood, seconded by Mr. Diaz, that cases 10 and 11 be dismissed per council's recommendation. Discussion. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 12, excuse me.
Number 12 is 2019-021331. Would you like me to read the summary or just go to the new information?
Good new info.
Okay. New information. Yeah, so this was just a mistake on my part. This matter should have been directed against the respondent's principal broker, who is responsible for maintenance and disbursement of escrow funds. I recommend the commission dismiss this matter against the named respondent and open an identical complaint against the principal broker.
Motion to accept council's recommendation.
Second.
Mr. Diaz makes a motion to accept council's recommendation. Ms. Taylor seconds that motion.
This respondent was a broker, but not the principal broker.
Right.
Okay. Okay.
Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 11.
Number 13.
18.
Like I said, number 13.
2019-022531. New information is as follows. Notice of this disciplinary action was sent to the person believed to be the respondent in this matter, but it has become apparent that they were misidentified or that someone misappropriated their name and information to create the listings. Respondent is a licensed agent in a neighboring state and recently began the process of applying for a reciprocal license in Tennessee. However, they are not the person responsible for the listings. It is possible that the party responsible stole respondent's information or that the complainant named respondent as the responsible party based upon their suspicion alone. In any event, council recommends this matter be dismissed.
Motion to accept council.
Second.
Diaz makes a motion to accept council's recommendation. Mr. Douglas seconds that motion. Is there discussion?
But I will.
It was me.
No,
I admit it.
In the opinion of the chair, it was Mr. Douglas.
It's fine.
The opinion of the chair doesn't matter much anymore, but I just wanted you to know that. All right. The motion is to accept council's recommendation and dismiss. Those in favor of that motion vote aye.
Aye.
Those opposed, no. Motion passes unanimously. 14.
14 is
New information, please.
Yeah, 2019-016611, new information. An attorney for respondent provided counsel with documentation which indicates respondent was not engaged in unlicensed practice. Included in the file was a sworn and notarized writing from respondent in which they state their daughter placed the yard sign on the property around December 2018. The yard sign originally had a for sale by owner sign taped to it, which they believe was likely blown away by bad weather. Respondent provided photographs in which tape residue is visible on the sign. Had the FSBO sign not been blown off, respondent's information on the sign underneath would not have been visible. Respondent's daughter also provided a written statement confirming they placed the sign with the taped for sale by owner designation in the yard, not respondent. Respondent also provided records which show they owned the property for 15 years before selling it to their daughter in 2013. Respondent concludes by stating they have been licensed for over 30 years in Florida, although they have been inactive for the past 3, and that they never intended to engage in any unlicensed activity. Council recommends this matter be dismissed.
Motion to accept council recommendation.
Yes, makes a motion to dismiss per council's recommendation. Mr. Moffitt seconded that motion. Discussion. Those in favor?
I have a question.
Yes.
Yep. So the first time we sent something to them, they didn't say anything about the sign being taped over. They were just saying that it was a family-owned property, right? So, but when it came out the second time, then there was a different story.
Well, so I don't think the story necessarily changed. When I spoke to their attorney about this, I said, listen, I'll review it and represent it, but you need to give me anything and everything that shows why this was an unlicensed activity. So they may not have thought it was an important distinction at first, but after I spoke with them and said it is, they gave it to us.
And when you said family-owned property, so the sign was daddy's and the property was daughter's, was that right?
Yes.
But daddy didn't own any of the property.
Technically, no, but it was a family property, and they weren't.
But you've got to be licensed if you're selling somebody else's property. So that is unlicensed activity.
They were selling their family-owned property. Yes, the name on the deed is the daughter, not the broker. But honestly, I'm not even sure that they were brokering the property. I mean, it sounds to me that
Sound like to me
they
they
were
were trying to
just using
get
the sign.
They were trying to get all the calls to go to daddy because daddy's more comfortable with talking to potential buyers.
I guess that's a possibility. I didn't see any indication to support that. I didn't find any evidence to support that. To me, this really just looks like the daughter's trying to sell the daughter's property. They used a sign, put for sale by owner on top of it. For sale by owner got blown away. It made it appear as though the broker was trying to engage in real estate practice. But I just, after speaking with all the parties, I really don't think this is a case that's good for discipline. I don't feel discipline is appropriate in this situation.
By the floor.
I want to offer a substitute motion for $1,000 civil penalty fund license activity. I would have felt. Go ahead. If you need a second.
I was looking back to see what we had done the first time.
Mr. Wood has made a motion that this respondent should be offered a $1,000 civil penalty. Is there a second to that motion?
I will second.
Taylor seconds the motion. Now, on the floor is a motion to offer. Are we offering the father or the daughter? Who are we offering this civil penalty
That's what
to?
I was wondering. Whose penalty is it to?
And really, it's the dad.
Yeah, the complaint
Because the daughter
was
has the
opened
right to sell her own
against-
property.
Right, and I really think that's what was happening here. Because if they put a for sale by owner sign up, then that would only suggest that the owner of the property was selling it. So
You had the fall.
That's the thing.
I think they were just using the sign to have something to put the for sale by owner designation on. Like the sign was just their template.
She's saying she believes like
In Florida.
they'll use our signs for a yard sale or something, that she used it for a for sale by owner.
Right,
You're assuming
yes.
that, and you're believing that they actually did have the for sale by owner on it at one point.
I believe them.
See, my concern was that wasn't their first answer. That was their second answer after the first answer didn't get them out.
But the first answer was, this is a family-owned lot. I'm not taking a commission on this. I'm not brokering the property. The second answer just gave us more reasons why it's not unlicensed activity.
So sometimes I'm trying to decide if Kelsey is too tough and sometimes too easy. I mean, that's not consistent yet. I mean, you're just not a bad person all the time on these things.
What's going on? I clearly missed something.
Somehow you became the subject of the conversation.
No, I mean, I understand.
Oh, well, that definitely should be dismissed.
All right, so the motion on the floor offered by Mr. Wood and seconded by Ms. Taylor, which we're going to vote on in a minute, would offer the father, the unlicensed participant, a $1,000 civil penalty.
I just don't know that I think that that's fair for the dad, who probably had nothing to do with any of this, to be hit with the penalty. If he lives in Florida, the daughter had a sign, put the sign in the yard.
Things dads do for their daughters.
Yeah. He could have had no knowledge of it at all.
Dad would figure it out when Dad was getting phone calls.
I will say it's not in a very public area. Like it doesn't seem like there's a lot of activity.
That doesn't factor into your thinking at all, does it, Bob?
I mean, I would feel different if we'd got the answer the first time. It's the fact that they had to. Here's our second time, and if this doesn't work in their favor, we may get a third answer at some point.
Well, a lot of times respondents aren't going to hire an attorney immediately, and when they do, I don't feel like this changes their answer. It's just when you get advice from somebody, when you have an attorney telling you, give me everything, they do. Whereas if they're just answering it on their own, probably in their head, they're like, well, I'm not doing unlicensed activity.
So you think
This
when
is
you
a no-brainer.
get an attorney involved, then the truth comes out? Is that what you're thinking?
Always.
Okay.
All right. So
I think the problem is we don't have enough real, true information, period.
here's where we're going. We have a substitute motion that offers a $1,000 civil penalty. If that fails, we'll go back to the original motion, which was to accept council's recommendation and dismiss. Joe.
I have one question. Was this sign have a Florida number on it, or did it have a Tennessee number? I mean, was it a local
Didn't
sign?
have a phone number. It only had a website, and the website is not for a firm. It's for like an online directory of agents. So it wasn't even like a traditional yard sign. It just had a picture of the agent and the website.
Of agents in wherever or in Tennessee?
It's a national directory. I don't really understand the purpose of the website, but it does exist.
So if I was driving by the sign, could I have contacted someone that would have had information on this lot if the for sale by owner sign had blown off?
You probably could have found the broker, or the Florida broker, through their name, but
Only if I knew he owned that lot. Are you saying that I would have to know who I'm looking for at that point? Like, could I have found out that 1234 Main Street?
sorry, the sign did have a phone number. That was my
Okay,
mistake. I
okay.
didn't remember.
All right, we're gonna take a vote. Hey, Caitlin, let's roll call again. This will be fine. Let's see. If you're in favor of a $1,000 civil penalty, you'll vote yes. If you're opposed, you'll vote no.
Roll call votes in one meeting.
No, we get new people. It's
It'd be wild and crazy.
Keeping me on my toes. Okay. Commissioner Joe Begley.
No.
Commissioner Jeff Diaz.
No.
Commissioner Rick Douglas,
Oh.
Commissioner John Moffett,
No.
Commissioner Fontaine Taylor,
No.
Commissioner Stacy Torbett,
No.
Commissioner Bobby Wood,
Yes.
Chairman John Grease.
Oh. All right, so that motion fails. I'm not sure why I did a roll call. I thought there'd be a little bit more diversity on that answer. Shows you what I know. Now we're back to the motion to accept council's recommendation and dismiss. Is there further discussion? Let's vote on that motion. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. So it was easy on the consent and a little tougher on the legal.
Yeah, but I thought that went pretty well.
You
gonna
did.
I'm going to be in a good mood the rest of the day.
That's because Kristen's up. Is everybody okay? You want to take a short break before we go on to Ms. Downing? All right, let's go. Number 15.
All right, number 15, 2019-045311. Complainant is an anonymous real estate licensee. Respondent is a real estate licensee. Complainant alleges that the respondent has several MLS listings that respondent refuses to remove due to the amount the listings sold for during the real estate transaction. Complainant alleges that respondent was asked by respondent's company to remove the listings. Complainant alleges that this is a clear ethical violation and that respondent's goal is to control the value of the community so that respondent can maintain sales and full customers. Respondent alleges that they have not intentionally maintained listings on MLS that have been closed with the goal of maintaining values and sales within communities or as a way to fool customers. Respondent alleges that they have never instructed, authorized, or empowered anyone operating under respondent's license to do so. Respondent alleges that neither respondent nor respondent's company had any knowledge that the listings remained pending after closing. Respondent alleges that this was merely a clerical oversight by a former affiliate who is no longer with respondent's company and who failed to transfer listings before leaving the company. Respondent alleges that once the oversight was brought to respondent's attention, respondent immediately closed the listings in MLS at the closing price for each individual property. Respondent alleges that they have implemented an internal system with one person managing the MLS listings to make sure that this does not happen in the future. Respondent alleges that any listings held by an associate leaving the company are to be transferred to another qualified associate prior to the associate's departure. Council's recommendation is a letter of instruction regarding Rule 1260-02-125C, which requires all listing information to be kept current and accurate.
Second.
Motion by Diaz, seconded by Mr. Wood. The council's recommendation be adopted, and this this letter of instruction be sent. Discussion. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 16.
Number 16, 2019-046211. Complainant is an anonymous real estate licensee. Respondent is a real estate licensee. Complainant alleges that respondent published an advertisement online that does not comply with the one-click rule linking to a firm name and required contact information. Complainant alleges that respondent continues to show online that respondent is with a firm that is closed. Complainant alleges that respondent is now with a new firm. Respondent alleges that the advertisement was an oversight as respondent has helped with promotion on different online platforms. Respondent alleges that the advertisement was posted before respondent had the opportunity to review the posting. Respondent alleges that they were unaware that their old firm name appeared on the listing. Respondent alleges that changes have been made to the posting and respondent will monitor postings more frequently in the future. Respondent alleges that they are licensed in 2 states and was just informed that the old name of one of the firms was changed without respondent's knowledge as the old name was still displayed at the office. Council's recommendation is a letter of instruction regarding Rule 1260-02-126B, which requires that social media advertising by licensees must include the firm name and telephone number listed on file with the Commission that is no more than one click away from the viewable page.
I'm just trying to figure out, how do you not know that your company has changed its name?
Yeah, I got stuck on that too, Commissioner Wood.
Well, the only explanation respondent gave for that is the fact that the respondent is licensed in 2 states and perhaps isn't privy to all the changes. Maybe it was a very recent change. I don't know. There was nothing else to give me any information about that.
Because if you're a broker, you're going to let everybody know what the new name is, because they got to change all their advertising.
That would be
That
my
would be a
thought,
big deal, not a little deal.
There's nothing else that this respondent gave me to explain why they didn't know, other than it just was something that was still, or not advertised, but posted in the office, so they didn't realize that it had changed. I think even the sign outside of the office maybe was in the process of being changed, but respondent just says that they didn't know.
Ms. Downey, so given what you just said, this is a recent company change. It's not something that happened a few years ago, and they just missed this one part.
Right, at the time when this complaint was filed, it was something that had just recently happened.
Okay.
Make a motion for a $500 civil penalty for improper advertising.
Second.
Wood makes a motion to offer this licensee a $500 civil penalty, and that was seconded by Mr. Diaz. Discussion on the motion. What do you think about that, Ms. Downey?
I think that the respondent had a duty and obligation to make sure they complied with the advertisement rules. I don't necessarily agree with the $500 civil penalty, considering this person has never been in trouble before and there's no disciplinary history, but it's not something that you're not within your rights to do. I just don't think it's necessary at this juncture, but yeah.
Douglas.
Do we know where the advertisement was advertised?
The other thing too, and I didn't put it in there because it's not really that important, but this was on Instagram, and this respondent more often uses Facebook, and I think there was like a family member who was trying to help her, and so, or help the respondent, so they were just kind of thrown off by what was posted on Instagram, because that's not their normal platform. But at the end of the day, it's their responsibility, which is why I said a letter of instruction.
The reason I asked that question is I think it is relevant, because if you post something in the MLS and you use, like, for List Hub or something, for instance, and it propagates to 100 different web portals, sometimes it gets out there in places you don't even know about, and it's still there. Once you go pending and once you even close, it's still there. And I would hate to hold this agent responsible for an advertisement that's out there that they didn't know anything about. So I'll vote no on that one.
Okay.
But I could bet you, if this agent didn't know their company name had changed, there's a lot more than this Instagram post that's a problem.
Perhaps
like every one of their signs are wrong. I mean, they got a lot of problems.
Perhaps we can upgrade to a letter of warning rather than just a letter of instruction, instead of, and maybe do some sort of compromise. Instead of doing a $500 civil penalty or being too lenient in doing a letter of instruction, we could do a letter of warning. But like I said, it is up to the commission, but that's just my advice.
All right. Commissioners, before we vote, the motion on the floor is to offer this licensee a $500 civil penalty. Is there further discussion? I almost want to have a roll call vote again, but I'm going to try without one. If you're in favor of the motion, vote aye.
Aye.
If you're opposed, vote no. No. Roll call vote.
Late number 16.
If you're in favor of the civil penalty of $500, you'll vote yes. If you're opposed, you vote no. Okay.
Okay. Commissioner Joe Begley?
Oh.
Commissioner Jeff Diaz?
Yes.
Commissioner Rick Douglas?
Oh.
Commissioner John Moffitt?
Oh.
Commissioner Fontaine Taylor? Commissioner Stacy Torbett? Commissioner Robbie Wood,
Yes.
Chairman John Grease.
Yes.
So
Does
the
any
noes
commissioner,
have it.
wait, just a minute. Does any commissioner wish to change his or her vote?
Wish to
All right,
what? Change the vote? Is that what
You can change your vote until it's announced. I just wanted to give anybody an opportunity to do that, particular one person I was thinking of, but what's the total?
It's the noes have it. It's 4-3, and one abstention.
So the motion failed. That's what you're
Yes.
trying. Okay, so that motion failed. Now, I don't think we had a motion other than that. So is there another motion someone would like to offer?
Make a motion that we accept council's recommendation.
I have a motion by Mr. Douglas. Is there a second? Mr. Moffett, second Sad. Discussion on that motion. Ms. Torbett, pull that microphone down there.
So is the motion as written, or did you change it to letter of warning?
I didn't make the motion, so it would be whatever.
So
Ms.
right now, it's letter of instruction.
I will defer to whatever.
Okay.
The motion on the floor is to accept council's recommendation, initial recommendation, or only recommendation, but what's printed in front of you. If you're in favor of that motion, please vote aye. If you're opposed, vote no.
No.
That motion passes on a 7 aye, 1 no vote. Mr. Wood votes no. Number 17.
2019-050611. Complainant is a real estate licensee. Respondent is an unlicensed firm. Complainant alleges that respondent is engaging in unlicensed activity. Complainant alleges that they received a letter in the mail from respondent regarding the sale of complainant's home. Complainant alleges that they called respondent to inform respondent that the letter they received could make individuals think or believe that it came from a real estate company. Complainant alleges that respondent advised that they are an investment company that buys houses rather than a real estate office or wholesale consignment company. Respondent alleges that they are a real estate investment company that buys houses. Respondent states that they were unable to respond to a letter sent to complainant as it was not attached to the complaint. I don't know what that's about because it was. But counsel conducted research regarding the complainant's allegations. It appears to counsel that the respondent is an investment firm that buys properties. The individuals on respondent's website list employees as house buying specialists, and each of these individuals are licensed real estate brokers. Counsel reviewed the letter included in complainant's complaint. There is a statement at the end of the letter that says, "We aim to make selling your house as simple and smooth as possible." Counsel can see how that this might be misleading as respondent is in the business of purchasing houses and not providing services to help sell homeowners' houses to other individuals. I recommend a letter of instruction regarding unlicensed activity.
Ms. Downey, in your review of this file, did you get a sense that this company is obviously in the acquisition business, but how do they dispose of the properties? Do they retain them? Were you able to determine that?
It looked to me like they just. Let me look at the website really quickly. It didn't look like they were in the business of like buying it and then acting as a real estate broker to sell it to individuals, although they do have licensed brokers who present themselves as home buying specialists. So even if they were doing that, if it were those brokers, then it wouldn't be a problem. But it doesn't appear that that's what they purport to do on their website. But I just want to look at it again just to make sure.
Just curious who those licensed brokers are. What firm are they with?
Are they employed?
All right. Sir?
Seems a little deceptive.
Which is why I was thinking we could do a letter of instruction just so that they understand that this could appear a certain way. So maybe you want to conduct yourself a little bit differently so that it doesn't appear to mislead individuals in what you're purporting to do. Schedule an appointment, and we will come out to your home to meet you, take a look at the property, and make you a cash offer on the spot. Read and review your no obligation cash offer and decide if it's right for you and your family. Remember, there are no banks, no fees, and no repairs needed. Once you accept the offer, we can close on your time frame at a local title company. Once we close, you get your cash. It's that simple.
I think there's a conflict of interest because they have a due diligence to homeowners to get the most value for their property. And if I go out there and make them a lowball offer and don't tell them that I may be able to market that property as an agent, seems to be a little deceptive to me. But
What I don't like myself is if the website says that they have employees who are licensed real estate brokers. To me, that's
I think they called it home buying specialist.
Okay, sorry, I'm looking at this again. It says Blackjack purchases, renovates, and sells homes. Or
Don't let her do that.
delete. Okay, the respondent purchases, renovates, and sells homes in Pensacola, Florida, in Tennessee. Its strategic business plan allows them to remain incredibly fair with cash offers. So it does appear that once they purchase the properties, they resell them. But that is where the brokers come in. So that's why they're there. So there's not a violation. I just think the letter that they send to people needs to be reworded because it sounds like when they send it, they're participating in unlicensed activity because the person on the letter isn't a broker.
So, to Commissioner Douglas's question, are the licensees, the brokers, are they employees of this company or are they members of a firm?
Well, let me look and see if I can find that out. Hold on. It looks like they're employees, but I mean, it doesn't really have a firm that they're affiliated with on here.
just wonder if you didn't accept their lowball offer, if they happen to have an agent to list a house handy.
All right, Commissioners, we can, I don't have in my notes we have any motion on the floor.
So we're on number 17, that's
Yes.
the correct number.
Yeah.
We are.
All right, we say you don't have
The chair just doesn't think he does, if
All
that
right,
tells
well,
you.
you have one now.
Okay, tell me what it is.
I recommend that we take legal counsel.
All right, motion by Ms. Taylor to accept council's recommendation. Is there a second?
I'll second.
Okay, for purposes of getting the motion on the floor, Mr. Diaz seconds the motion. Now discussion. You can speak for or against the motion, or we can go to a vote, and you can express yourself at that point just as well.
I think since we don't really know the answer.
I'm almost thinking because we got so many things that they're still trying to figure out, maybe we ought to put this thing off a month and let them look into it a little bit more.
Right here, substitute motion, Mr. Wood.
That's, if by common consent, if is there any objection to putting this off a month? What more would you like to know, Bobby?
I think Kristen was just trying to figure out if they were employees and just kind of find out a little bit more about the situation and
I mean, I don't mind looking into it further. It looks like just on its face on their website, these people are employed. They're employed by the investment company, and they have like their email address with that same handle as the company. So, I mean, that would be my assumption.
Oh, we need to make a decision. There's a motion on the floor, which is to accept council's recommendation. There's a suggestion at this point that maybe we defer this for 30 days to get additional information. You want to go ahead and formalize that just so we can...
I'll tell you what, I'm good with us going ahead and voting, so let's take mine off the table.
Okay.
Let's just do that.
So now at this point, we've got a motion to accept council's recommendation. Further discussion. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 18. And maybe this is a quick summary you could give us on this one without having to read into the record.
Okay, so basically, this complainant is saying that the respondent participated in discriminatory steering when they were trying to purchase or put an offer on a home. It's just really the complainant's word against the respondents. They didn't really attach anything to support it, and I think this is probably something more suited for the Tennessee Human Rights Commission. So my recommendation was to dismiss it and refer to that commission.
I will make a motion that we just dismiss it and not send it anywhere else because there was nothing in here to support it. I mean, the short story was they were one of 20 offers, and then they want to think that their offer was not accepted because maybe what they look like. And even though the listing agent said, I have no idea what they look like, I never saw them. So my motion is just to dismiss.
I'll second.
The motion is to dismiss, offered by Mr. Woods, seconded by Mr. Diaz. If you're in favor of that motion, in a moment we'll vote. You'll vote yes. If you're opposed, you'll vote no. Council's recommendation was to dismiss and then refer it to the Tennessee Human Rights Commission. And so if you lean toward council's recommendation, you'll vote no on the vote we take in just a moment. Okay? So are you ready to vote? Let's vote. If you're in favor of dismissing this complaint, please vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. Number 19.
2019-052511. Complainant is a Tennessee resident. Respondent is a real estate licensee. Complainant alleges that they closed on a home on May 7, 2019. A home inspection was performed on the property on March 18, 2019, where no issues were found that would exclude the home from a USDA loan. Since the closing date, complainant alleges that an outside contractor provided by complainant's insurance company has found mold and prior water damage that were covered up by the previous homeowner. Complainant alleges that as of now, their new home's kitchen and dining area have the floor pulled up and covered in plastic at the direction of the complainant's insurance adjuster. Complainant alleges that their neighbor showed complainant evidence that the prior tenants mentioned the mold issues in to the prior owners. They didn't provide counsel with any of that documentation. Respondent alleges that they had no knowledge of the mold issue located within the home. Respondent alleges that a property exemption disclosure was provided to the complainant as respondent's client had not lived in the property for over 3 years. Respondent alleges that the complainant had a home inspection performed and signed off on the final inspection stating that complainant accepted the home in its as-is condition is notated on the final inspection. The inspection was attached. Council's recommendation is to dismiss and refer to the home inspector licensing program because it just appears to be an issue with the inspection, not with the sellers.
I'll make the motion to accept council's recommendation.
Motion by Mr. Woods, second by Ms. Taylor. Council's recommendation be adopted. Let's vote. If you're in favor of that motion, vote aye.
Aye.
If you vote no, it passes unanimously. Number 20.
2019-052-701. Complainant is a Tennessee resident. Respondent is a real estate licensee with an expired license. Complainant alleges that respondent owns a property management company and has been managing several properties without a valid real estate license. Complainant alleges that respondent has been extremely unprofessional. Complainant alleges that respondent has not been maintaining the properties that they are paid to manage. Complainant alleges that on May 24th and May 28th, respondent potentially violated a contract that the homeowner has with a company for repairs and or replacement equipment by sending respondent's personal maintenance person to attempt to do the repairs and telling complainant not to mention it to anyone. Complainant alleges that respondent's license has been expired since June of 2010. Complainant alleges that they have had to do several repairs independently as complainant refuses to address any issues and says as long as it still works, then it's fine. Complainant alleges that respondent manages properties and possibly sold properties for someone. Respondent failed to provide a response initially. A copy of the complainant's complaint was sent to respondent back in June, and a past due letter was sent on June 26, 2019. So counsel reached out to respondent on October 11, 2019 to inquire as to whether respondent intended to file a response. Respondent alleges that they were the property manager at the time complainant rented the property. Respondent alleges that complainant filed this complaint because complainant was being evicted from the property. Respondent alleges that complainant moved from the house and stole the owner's possessions. Respondent alleges that there is a trial set in civil court against the complainant for the outstanding amount of $10,000. The respondent said that they would give me a response, like a formal one, but I never got one. So I performed an independent investigation and determined that complainant does appear to own a property management company that also operates as a rental type of location firm, not relocation. It does not appear that respondent is licensed to perform rental location activity. So I recommend a civil penalty of $1,000 for unlicensed activity in violation of TCA 62-25-103A and Rule 1260-03-01.
In that last paragraph, that respondent does appear to own a property management company?
Right, but they're also appearing to act as a rental location firm, but there's no license for that, and they have an expired real estate license, so they can't use that.
It states that complainant appears.
I'm sorry, respondent. Sorry.
Yeah, that's what I was.
It gets a little confusing, guys. Sorry about that.
Okay, but they've, so they're unlicensed right now, but because they were a licensee, are they still responsible for, when we send a complaint out, are they still responsible for filing a response? Or once their license is expired, they have no responsibility to us anymore?
They don't have to respond. The only thing is I emailed this person and they said they would give a more formal response. They did tell me a little bit, but even with them saying they would respond, they have no obligation to with an expired license. However, I take issue with the unlicensed activity. So.
And see, and I also look at it too, this is 9 years. I mean,
since the license expired.
Yeah,
Mm-hmm.
They've been operating 9 years.
Mm-hmm.
I mean, would you have thought about maybe doing more than $1,000? I mean, they've been operating 9 years.
I mean, I think the $1,000 civil penalty is appropriate because I don't know how long they've been operating this rental location firm. I know that their license has been expired for quite some time, but I don't know how long this particular situation has been going on. So I would say $1,000 would be appropriate, and if it continues and we get more complaints, perhaps we can increase that, or if we get more evidence of how long this has been going on. But without more, I just don't think it's appropriate to try to do anything more than the $1,000 penalty.
So the only way for you to determine if you think it's more appropriate to do more is you need to go back and do more work on it? Is that what you're thinking?
No, what I'm thinking is if there are specific instances where they've made this violation so many times over, I don't know, several years, then and if that evidence is presented, then I would recommend more. But that's not what I have in front of me, and it's not something that I need to go back and do work on to assess a penalty or recommend assessing a penalty.
That is something that where like each day would be a separate violation, Bobby? Is that what you're thinking?
I'm
I
like,
think
show
that's
them
what
grace. Each year would be a separate violation. I mean, good night. I mean,
To
how
get
do
his
you-
attention, though, wouldn't it?
How do you not think of it at some point over a 9-year period? You know, I don't remember paying my licensing fee.
That'll feel, but, you know, if they're May 28th, 24th, they would have rented for at least 6 months, and you know a year, so that's 2 years right there, Bobby.
What's the maximum civil penalty that we can assess on this?
$1,000
per
Occurrence.
Per occurrence?
Right.
Each day could be an occurrence.
So we don't know how many occurrences
We don't
there are,
have
though,
that
so-
in front of us to go off of. We have the complaint, and we have what respondent gave us as a response before they did a formal response, which they never gave me. But what we have in front of us is just the one, and it wasn't even.
It's most likely.
What do you mean?
Like most.
I really don't know.
Okay, I'm going to make a motion of a civil penalty for unlicensed activity, and it's $1,000 for every year they've been unlicensed, and that's $9,000.
Is there a second to that motion? Ms. Taylor seconds that motion. So that's a total of $9,000.
Correct.
Okay.
Ms.
All right, we've got council's position.
No, we cannot do that. We don't have evidence of 9 years of unlicensed activity. We have this one instance before us. We don't know if they've been doing that since 2010.
And honestly, we're not likely to find that out.
Well, I thank you for counsel. We have a motion on the floor, and if it passes, that's the judgment of this commission. If it fails, we'll go to a second motion. Okay?
Let me ask you this. You cannot, you know, how did you know his license had been expired since June of 2010? Because the person that wrote in said that?
No, that's from a search in our records.
You know that?
Yes.
Know that they're doing anything else in real estate? Do you know that at all?
No, we don't know that information.
Good point.
But they had an
Real estate-
opportunity
But if they're
to
doing real estate 9 years later, I don't know.
Well, I mean,
All right, we're going to.
that's an assumption. We just don't have evidence of it.
We're going to have to rely on a vote on this one. If you're in favor of, when we vote in just a second, offering this person, a former licensee, a $9,000 civil penalty for 9 years of practicing real estate without a license, you'll vote yes. If you're opposed to it, you'll vote no. That's what's in front of us. Okay? Since we're ready to vote, if you're in favor of the motion to offer a $9,000 civil penalty, please vote aye.
Aye.
If you're opposed, please vote no.
No.
All right, the chair, in his wisdom, says that motion fails.
Motion to accept council's recommendation.
7 aye and 1 no vote. No, 1 aye vote and 7 no votes. All right, now,
Motion to accept council's recommendation.
Mr. Diaz makes a motion to accept council's recommendation. Mr. Douglas seconds that motion. Is there discussion on council's recommendation? Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed vote no. That
No.
motion passes on a 7 aye, 1 no vote. Mr. Wood votes no. Number 21.
2019-053011. Complainant is a Tennessee home buyer. Respondent is a real estate licensee. Complainant alleges that in March of 2019, complainant hired respondent to assist with the purchase of a property in Tennessee. Complainant alleges that they entered a contract for the sale of a home, and a home inspection was conducted on May 7, 2019. Complainant alleges that after the home inspection, complainant no longer wanted to purchase the property. Complainant informed respondent of this on May 17th of 2019 and further stated that complainant did not wish to continue searching for a home to purchase.
Can I ask a question? So is this whole complaint's about earnest money, is that right?
Correct.
But but the complaint's against the affiliate broker. Shouldn't it really been against the broker? the affiliate wouldn't have control over the earnest money.
What?
My thinking is, if I'm right, we should dismiss it against the affiliate, but then open it against the broker.
Why don't you make that motion?
That's my motion.
Okay, that's probably better. I didn't even.
The motion on the floor is to dismiss this complaint and ask administration to open up a complaint against the principal broker involved in this transaction. Mr. Wood made the motion, Ms. Taylor seconded it. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. Number 22.
2019-054251. Complainant is a Tennessee resident. Respondent is a registered timeshare resort. Complainant alleges that they purchased a timeshare interest for $45,000 with a down payment of $5,000. Complainant states that the timeshare interest is now a financial burden. Complainant attached a copy of the purchase agreement. Respondent states that complainant did not provide a valid reason for canceling the contract. Respondent states that the purchase agreement provides that respondent had 5 days from the date of purchase to cancel the contract, but complainant failed to do so, and therefore the contract cannot be canceled. Respondent attached a copy of the purchase agreement. Counsel reviewed the attachments from both the complainant and the respondent. The purchase agreement indicates that there is a rescission period of 5 days. However, this is not in compliance with the statutory requirements of TCA 6632-112-9, which requires a 10 or 15-day rescission period, depending on whether the owner of the timeshare interest viewed the property or not. Counsel recommends instruction.
Ms. Downey, does it matter where the timeshare property is located, or is this basically, if the timeshare property is in the state, does that change the rescission period requirements?
They entered the contract in Tennessee, and I believe I don't think that necessarily matters in this situation, because this wasn't like a physical property that was attached to the timeshare. It was more like her or the complainant acquiring points and then just being able to go wherever they wanted to go with respect to the timeshare.
It's more of a network.
Right.
Well, when did the complainant actually try to exercise the right of rescission?
And see, my issue with this is, well, the complainant didn't exercise their right to rescission within the 10 or 15, even if they did put it in there. My issue is that people, this may have affected people who may have had more time and were told that they didn't. So I just don't want that to happen in the future, and I don't have any evidence that this has happened, but it's just my concern, and if they aren't aware of this, then they need to be aware of it.
Oh, you're too nice sometimes. Okay, we're talking about timeshare companies who dot every I and cross every T. I'm guessing this was a pre-printed form, right? Was it?
It looked to be.
I mean, the right of rescission, they said 5 days. I mean, they don't need a letter of instruction on that. I mean, this is an opportunity. If I knew that they did that to 10 different customers, I'd be writing Bobby Wood's camp at $1,000 a customer. Because these guys never mess up. And I don't know if this is intentional or unintentional, but a letter of instruction, they don't need that. They know the law. My opinion. Those are my comments.
Mr. Chairman, do you have a motion?
I don't make motions, but I'd certainly vote for one that offered like $1,000 civil penalty.
I'll make that motion.
Mr. Moffitt makes the motion to offer this respondent $1,000 civil penalty, and Ms. Taylor seconds that motion.
For what violation?
Well, because for misstating the law, I don't know if we can categorize it, but that's what they've done.
Well, it's for not in compliance with the requirements of TCA 6632.
Thank you, Ms. Taylor. All right, the motion on the floor is to offer the respondent a $1,000 civil penalty. If you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. 23.
2019-05-6671. This complaint was filed internally as a result of the mandatory real estate firm audit. Respondent is a real estate licensee. Complainant alleges that respondent failed to comply with TCA 6213-312B5 and Rule 1260-02-0911 regarding management of trust accounts. Complainant states that one of the respondent's real estate transactions had deposit delay in excess of the timeline identified in the binding agreement. Respondent alleges that the binding date of the contract was upon completion of negotiations without the earnest money being in possession of respondent's firm. Respondent states that the earnest money is always deposited upon receipt. Respondent also states that due to the location of their firm, they sometimes have delays with the deposit of the earnest money as they are usually far from the other licensee involved in the transaction. Respondent states that they have made necessary changes to make sure this problem does not occur again. Council recommends a letter of instruction.
So what was what did they do wrong?
They had delays in management of their trust accounts. They had delays in, I guess, what was outlined in the contract.
Was it one case or is it multiple ones?
It was with, hold on.
Was there one?
One of them, yeah, one real estate transaction.
Do you know the binding agreement date on this contract that's the problem? What I'm going to look for is the binding agreement date, the deposit date, and the days on the contract that the earnest money had to be deposited with him.
So the contract date was March 31st, 2018, and the deposit date was 4/11/2018, and the deadline was 4/5/2018. So it's a 4-day difference.
Delay. It's like,
Okay, now the date that you gave of 3/31, is that the binding agreement date or the contract date? You
That's
said
the contract date.
Okay, what's the binding agreement date?
You mean the deposit
Nope.
deadline?
Binding agreement or acknowledgement of receipt. It would have said binding agreement date on that contract in 18.
I think they restated now. And
Okay.
yeah.
It's 3/30/2018.
So they got it worked out the first day that they made the offer.
That's what it appears on this. Well, hold on.
Okay, so
it's a lot of documents in here, so hold on.
Okay, look at the last. There was a counter. Look on the last counter, and it should have at the bottom, near the bottom of the page, about when it was bound.
It's 3/31.
So it would have to be.
Yeah, because it doesn't really have anything else.
You don't have a binding agreement date. How can you tell if the deposit's late?
Look at the last page of the contract itself.
It looks like 3/31. It's just like printed in there. It's not like written in there.
It's an electronic signature that has the date on it. Yeah,
Right.
sometimes those are hard to read. So that's in the place where it says the date that the last offeree received a copy of it.
3/31. Yeah.
I'd like to make a motion to accept council's recommendation.
Ms. Downey, the one other question I had, You say that the respondent is a real estate licensee? That's not a broker? Is it an affiliate or?
It's a firm. A firm.
Okay, thank you.
Sorry.
I'll second the motion.
Motion on the floor is to accept council's recommendation. Is there discussion?
Okay, on the, there's a page, about the third page in, that says deposit of earnest money within how many days? Do you see that?
Should be right out near where the earnest money is on the contract. You can tell how much the earnest money and who holds it and how many days.
$3 days. It's on that other.
3 days, so that passed.
Okay, the motion is to accept council's recommendation. Mr. Wood, you okay with that?
Good with that.
Okay.
Let's go.
All right, let's vote on the motion. If you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no. The motion passes unanimously. With that objection, unless you have it, I'm going to take about a 5-minute break. Let people get up for a second, including myself.
Right. 2019-057161. Complainant is a Tennessee homeowner. Respondent is a real estate licensee. Complainant alleges that they put their home on the market and received an offer from the respondent's client that was contingent upon the buyer's inspection. Complainant made all necessary repairs per the inspection and prepared the property for closing. Complainant went by the property one last time on June 8, 2019 to make sure that everything was ready for the buyers and the closing the following Monday. When they arrived at the property, they discovered items that did not belong to them in the garage. They entered the house and found empty champagne glasses and bottles in the kitchen, along with beer cans, a coffee maker, a liquor bottle, and other items throughout the home. Complainant called their agent to inquire about the miss. Their agent advised that respondent's clients requested to come by with the decorator, but it appeared that the respondent's clients were given a key and permission to move items into the unit 2 days before closing. Complainant found no damage to the property, so proceeded with the closing on the following Monday. On June 10, 2019, the closing was set to occur at 2 o'clock. The closing and wire transfer of funds was delayed for some unknown reason, but it finally occurred on Tuesday afternoon around 4 o'clock. Complainant further alleges that respondent was unlicensed during the real estate transaction. Complainant alleges that respondent is no longer licensed. Complainant alleges that respondent is no longer licensed as a real estate agent and that respondent's license expired on April 15, 2019.
Chairman Grease, can I try this?
Do it.
Okay. If I got it right, there was one issue was the respondent was unlicensed at the time this was going on.
Mm-hmm.
So there's an unlicensed activity issue. And then the second thing is that agent gave the key to the property to the buyers and prior to closing, and it sounds like the seller didn't even know about it. Am I right with that?
That's pretty much correct.
Okay, so to me, there's two violations there, and this is a big deal. I mean, you're basically giving somebody else complete possession of their house, and they're not even knowing it. And so I think that warrants a lot more than a letter of instruction. And so what I would have, I would have 2 civil penalties: one for unlicensed activity for $1,000. One for not exercising reasonable skill and care for $1,000, and also a 4-hour contracts class they got to take within 180 days, and they don't get CE credit for.
Okay, so if I could finish just this last part. I did an investigation on this, and the respondent's license did expire on the April 15th, and their status changed to expired on June of June 16th of 19, and then respondent submitted a request to reinstate in June 29th of 2019, and then the reinstatement was approved. And so I just didn't think that a civil penalty was something that would be appropriate for the expired license in this situation. But I mean, I agree with you on the reasonable care, but I don't think you need two different civil penalties for those.
Okay, so why do you think not having your license active is not a big deal?
Well, I didn't say it's not a big deal. I just think that there were some circumstances that caused the lapse in her license. But
what was the circumstance?
Let me make sure this is the one that I'm thinking about. She had changed firms, and her renewal notice was sent to the old firm, and they didn't notify her of that. And then her daughter was diagnosed with colon cancer, so the respondent had a lot going on at the time when her renewal was supposed to be happening, and just wasn't aware that the license had expired. So I just think with those circumstances and this respondent's lack of any discipline in the past was something that should be considered. But I do agree with you regarding the civil penalty for allowing people to come into the property.
And see, the thing you got to remember, us as agents, we got 2 years to know when that license is coming up. We got 2 years to get our education, 2 years to do it. And I mean, and we all have issues that come up, and I mean, this was a big issue, but they had a long time, and so that's why I'm not quite as.
I mean, I'm not going to fight you on it. That's just my thought.
That's not what you've been doing here the last couple hours now.
I'm not trying to be difficult, but I want you guys to think about all of it in total, and not just in a vacuum, and consider everything. And that's my job, is to tell y'all everything and make sure you're doing the right thing. So
you get to read about it and think about it. Several of us up here live it every day. I mean, that's what we do. So
understood.
So can I ask one thing, Kristen? So from the Real Estate Commission's perspective, or the public's perspective, if you went to look at Verify, you would never know this license had expired, right? Because once you reinstate it, it goes back to your initial issue date.
Right.
So I can make the argument that it never expired. But you don't buy that argument, do you?
Well, I want to put things in perspective. Let's say if you're driving a car and you have a wreck, and your insurance expired yesterday, the day before. What do you think the insurance company is going to do about paying for your car that got wrecked?
Tell you to kick rocks.
They're obviously not going to pay for it, and I totally understand.
Do they care? Do they care why you didn't pay it, or
you're right.
The post office was closed? No.
You're right.
So,
But in this case, insurance does go back and cover. It's got to say,
Hey, you have a 30-day grace period on insurance.
no, I think depending on who the insurance company is, if you reinstitute it within a certain period of time, reinstitute your license, it goes back and picks up that period.
well,
Yeah, it does. But
I'm not trying to argue for or against. I'm just
The insurance company cares or not, I mean, we do, and we
Yeah.
do take into account other factors, right?
Commissioner Wood, did you make a motion, or?
I did make a motion.
You did?
you did. Here it
Do you
is.
want me to tell it again?
Here it is.
see if I can tell him.
Okay.
The motion I think Mr. Wood made was to offer this licensee a civil penalty of $2,000 made up of two $1,000 components. One for failure to exercise reasonable skill and care, and the other was practicing real estate without a license.
And then the contracts class, the 4 hours.
Oh, it's a 4-hour contract class. So, I know you made that motion, but I'm not sure who seconded it. Mr. Moffitt seconded it. Okay. So that's on the floor We can have discussion on that. If there's a substitute motion someone would like to make, that's fine. Otherwise, we're going to vote on the motion. Mr. Douglas.
State it again.
Yep. 2 violations, $1,000 each, one for unlicensed activity, one for failure to exercise reasonable skill and care, plus a 4-hour contracts course to be completed within 180 days, credit for which does not apply to your continuing education requirements. Now, Anna or one of you attorneys, can we find them guilty of, or not guilty, in violation of reasonable skill and care when they don't have a license?
Incident. I would think we would want to look, okay, so this complaint was opened on 6/26/2019, and at that point in time, they were unlicensed. So I would look at the time that the conduct happened and say that if they were unlicensed, I think it would just be either or. So it would be just for unlicensed activity.
I don't know what you think about that, Mr. Wood, because if you look at verified...
But see, I don't like that because then now they're benefiting from the fact they don't have a license. But they were able to go out and earn commissions but not have a license.
I don't think we've done that in the
Yeah.
past. I don't remember dealing with things like that in the past. We have to be consistent.
Well, and you also have to look at the original license date. I mean, it's 1978. They're not a new licensee, so they are
But,
well familiar with the requirements for keeping their license maintained.
That particular statute applies to licensees, so if they're not licensed at that point in period, we cannot find them in violation of that.
But my sense is we can't get them for both. Now, you may have a different sense, and I'm all about it, but that's my sense.
I'm just using common sense.
I know.
I kind of got the feeling that they should get that for that.
I'm kind of channeling with the attorneys right now myself. That's where I'm coming from.
No, but the maximum penalty for unlicensed activity is $1,000. Yeah.
But the motion on the floor is to offer 2 $1,000 civil penalties. Now,
I'd like to
divide the question.
make a substitute motion that we just
Okay.
violate $1,000 civil penalty for unlicensed activity.
Follow my logic, then can you offer them a contracts course too? I don't see why not. Do you want to include a contracts course with that, Jeff?
Sure.
Because, in fact, their license retroactively was extended without interruption.
I'll add the 4-hour contracts course, 180 days above and beyond their CE requirements.
Is there a second to that motion?
Second.
Ms. Taylor seconds Mr. Diaz's motion, which would be a $1,000 civil penalty for unlicensed activity. Ms.
Can you
Matlock.
explain the contracts class to me? Like, so if they're unlicensed, we're having them complete a real estate contracts class. So the thing is, when your license expires on, let's say, November 13th, 2019, that's the date. You have an expired grace period of 30 days, which means you're not going to incur penalties. However, your license is still expired at that time period, so it doesn't necessarily, I guess, relate back at that time period.
I would make the argument this is a little different case. This is a licensee who just let her license or his license expire. I mean, it won't hurt that person to get a contracts course that says you don't give keys to people before the owner gives you permission to do so. I can justify that. I agree with you on the either or as far as the civil penalty goes. I don't think we can do both.
Right. Yeah, and there's an offer, so it's just a consent order, so.
Yep. Okay, so the motion on the
we'll
floor, Mr. Diaz made the motion, Ms. Taylor seconded, is a $1,000 civil penalty for unlicensed activity plus a 4-hour contracts course with the typical conditions attached. All right, you ready to vote? Let's do it. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 25. Kristen, before you start, you'll help me out. Is the respondent or the complainant the Tennessee resident?
They're on the 25.
Yeah.
They're both Tennessee residents.
So is the complainant the real estate licensee?
They're both real estate licensees.
Oh, okay.
I'm sorry. I'm wrong. The respondent, hold on.
The respondent's an affiliate.
Yeah, the respondent's an affiliate broker. I just put Tennessee resident there. But it's an affiliate broker. And the complainant is a real estate licensee, but they're both licensees. Yeah, sorry about that. It's a little backwards. That makes sense?
I'm only confused because typically the complainant is introduced first.
Yeah, I
Okay,
realized.
that's what got me.
Complaint or 2019-05-7391. Complainant alleges that they had a difficult time with communicating with respondent during the real estate transaction. Complainant alleges that respondent's own clients were upset with respondent's lack of communication. Complainant alleges that respondent wanted to take 3.5% commission and give the complainant's agent 2.5%. Okay, let me go back. So this one, I got this one confused with a different one. The complainant was a Tennessee resident, not a licensee. Sorry about that. It just got confused with a different one. But anyway, so complainant alleges that respondent wanted to take a 3.5% commission and gave the complainant's agent 2.5%. And give the complainant's agent 2.5% and threaten not to go through with the transaction if the complainant's agent did not agree to these terms. Complainant states that they reached out to the seller to inform the seller of the respondent's behavior, and they both determined that the behavior was unethical and extortion. Respondent filed a response alleging that buyer's agent knew how much the compensation was when the house was shown to the complainant, as this information was included in the MLS listing and the compensation agreement. Respondent alleges that complainant's agent never mentioned any issues with the compensation until about 24 hours before the closing. Respondent alleges that they had a conversation with the buyer's agent explaining that respondent had to pay a 25% referral fee out of their 3.5% commission. Respondent attached the MLS listing and compensation agreement to the response. Counsel reviewed the attached documents. It appears that the buyer's agent's commission is listed as 2.5% on both documents. However, the respondent's alleged threat to terminate the real estate transaction based on the issues with the compensation may have constituted a breach in respondent's duty of loyalty to their client. Counsel recommends a letter of instruction.
So
basically, the parties to the transaction, both the buyer and the seller, talked about this issue that occurred, and they both agreed that what the seller's agent was doing was unethical. And so they wanted to file a complaint against this person because of his or their behavior in not wanting to continue with the transaction unless they got that agreement regarding the split in compensation for the commission. And there isn't really a rule directly on point against this behavior, other than the fact that you're not really doing what's in the best interest of your client if you're willing to kill a whole real estate transaction because you have some disagreements with commissions.
Let me ask you this. On the compensation agreement in the contract, what did it say?
It did have that information
At
about
what, 25 and 35?
No, 2.5 and then 3.5.
Then they cannot do that, period. And it needs more than a letter of instruction.
Hey, I'm sorry, they can't do what I didn't.
They can't, you can't use a commission as bargaining tool.
Right,
to close.
right.
That is, you cannot
I
do
agree.
that.
Right.
So, and if it says it not only on the multiple listing what they were going to get, but it says it's on the compensation agreement in the contract, that's it.
So the person wasn't, okay, they weren't disputing what was said in the agreement. They just didn't feel that.
Doesn't make any difference how they feel.
Well, the respondent isn't the person who's saying, hey, you should get less, and trying to change the agreement. The complainant's agent was the one who had an issue with it.
That's what I'm saying.
Okay, I
That's
just
what
want to
I'm
make sure
saying.
we were on the
The
same page.
compensation agreement is between the agents. It's
Right,
not between
right.
anybody else. So they're wrong, and it takes
Well-
more than a letter of instruction.
Well, I agree
Who's
that,
wrong?
I agree that it's unethical, but isn't that a question for the local association and not the real
And
estate
that
commission?
that was my point. There's nothing statutory or in the rules that says you can't disagree about the compensation or the commission. What I had a problem with was the fact that they were willing to delay and cause issues with the transaction at the expense of the client, and that's a breach of the duty of loyalty. That was my issue with this, not necessarily the discrepancy with the commission.
I have to go back in my brain, which is hard. But there's something where it may be in the Code of Ethics or something where you cannot do that. And if they have both signed the compensation agreement, both agents have signed that, you cannot renegotiate at the end and say you will not close. An agent cannot take that position.
So you're saying the complainant's agent who hasn't filed a complaint is the one who's wrong and coming to the respondent and saying, hey, no, I don't like this agreement anymore. So the respondent is the person who did that. The complainant's agent did that.
Respondent
The respondent's just saying, look, this was the agreement.
Yes, that's
So,
true.
yeah.
That's what he was offered in
Right,
the
so-
multiple listing.
Yeah, so you're saying the respondent didn't do anything wrong. The complainant who tried to change the agreement is the issue.
Correct.
Okay, we're on the same page. So that person, there's no complaint that's been filed against the complainant's agent. It's against the respondent who drew up the agreement and had the agreement initially. So I didn't have a problem with the fact that the respondent wanted to do 2.5 and 3.5. I had a problem with the respondent trying to kill the transaction because of that.
Unless I'm on the whole different story.
You're on the right page.
Well, but once the compensation is offered, it is not up to any agent to try to change that.
Mhm.
Okay, that's what I'm saying.
Yes, I agree with you.
So
Can I make?
Go ahead.
I just want to make sure I understand who everyone is.
That's what I was
Yeah,
going to say.
it's confusing
All right, so
because
who is the complainant?
the complainant is the home buyer.
And who's the respondent? Is it the listing agent?
respondent is the listing agent.
Okay. Well, the listing agent did nothing wrong.
Right, that's what I'm saying.
So then what were we going to send
So
them a letter of instruction about?
The only problem I had, and I was a little conflicted about this, and so I spoke with Denard and just kind of got some insight. But you do have a duty to your client, even though you and the other agent aren't seeing eye to eye on something, which that particular agent who had an issue with the compensation plan wasn't right.
But that's
So
not- that person's
that's
not in the
this
complaint.
person,
Okay.
but you still have a duty to your client, and you can't make threats to not
An alleged threat, though. It didn't say that there was for certain a threat. correct?
alleged threat, but this respondent never denied it. What the respondent said was, look, this was the agreement, so I had every right to say what I said, but I don't think that person was considering their client, and that's why I said the letter of instruction, but again. it
Sounds
was-
like the buyer's agent was just upset that they were only getting 2.5%. And then the listing agent said, well, here's why I'm doing this, because I had to pay a 25% referral fee to get this listing, right?
That's
and just explaining why. And I'd just like to make a motion to dismiss.
Second.
Mr. Douglas makes a motion to dismiss. Mr. Wood seconds that motion. Discussion on the motion. Let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 26.
2019-057601. Complainant is a real estate licensee. Respondent is a real estate licensee. Complainant alleges that respondent has violated the advertising rules by failing to include an office number on the advertisement. The complainant also alleges that the firm name used on the advertisement is not the firm name registered with the commission. Finally, the complainant alleges that the firm name is not the same size or larger than the name of the licensee. Complainant attached pictures of the advertisement to the complaint. Respondent filed a response stating that the firm's phone number is listed on the bottom right corner of the advertisement. Respondent attached a picture of the advertisement to the complaint. Counsel reviewed the attachments provided by both the complainant and respondent. The firm name does appear on the advertisement in the right corner of the advertisement. The font is similar in size to the respondent's name. The firm phone number listed on the the firm phone number listed does not match the firm number on file with the commission. It appears that the firm number listed on the advertisement is one number off from the number on file with the commission, but everything else appeared to be correct. So I recommend a letter of instruction regarding the advertising rules with respect to the firm number.
But was the agent's number on the sign as well, advertisement?
It has the firm's number, which was one number off, and then in a small little corner, it has the agent's number.
All right, commissioners.
When you say the firm name and respondent's name are similar, are they the same or?
The number and the
size.
The size. He's got better ones.
Tell us what the one right number was and what the wrong number was.
I don't remember. I didn't write
could it be a 2 and a 3 and somebody?
But it was like a. I don't remember. I don't want to. It could have been a typo on our end. It could have been a typo on their end. But I think from looking online and looking just on Google, it looks like it was the licensee's mistake and not our mistake. Where is this? And what was your question again, Commissioner Wood?
When you were it says in your summary that the respondent's name and the firm name are similar.
Oh, yeah, okay. So the size of it, I mean, they don't look that different in size.
Yeah. So you're saying they're the same?
It's just the issue. I can't tell for certain because they've got them kind of spaced out a little bit. So the firm name is like in the bottom right corner, and then the licensee's name is in the middle of the advertisement. But they look the same in size.
So if someone looked at that sign, they would know what firm to call.
They would know what firm.
Yeah, I mean that's the intent, right?
Right.
Okay, Commission, can I have a motion?
I'd like to make a motion to dismiss.
Second.
Motion by Mr. Douglas, seconded by Ms. Taylor, that this complaint be dismissed. Discussion. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. 27.
2019-058831. Complainant is a Tennessee resident. Respondent is a real estate licensee. Complainant alleges that respondent conducted themselves in an unprofessional manner and extorted $2,000 from the real estate transaction at the closing for repairs needed after respondent agreed to the repairs during the final walkthrough. Complainant alleges that the respondent funneled the $2,000 collected at the closing back into the construction company that is owned by respondent. Respondent filed a response via their attorney. Respondent alleges.
Let me.
Yeah.
If I got the gist of this, it was they negotiated over some repairs, and then after the fact, one side is complaining about maybe they didn't like what they agreed to, and really the issue is between the seller and the buyer over the repairs.
Well, okay, I'll just quickly summarize it. So, there were some issues with the house. They did agree to specific repairs. However, the real estate licensee, their spouse was the person who owned the company doing the repairs. So they agreed that the real estate licensee's husband would do the repairs, but then the sellers conducted the repairs, and they just agreed, okay, fine, we'll let you guys do it, but we want to do a final walkthrough. So the licensee's spouse sent someone on their behalf to inspect the property, and they discovered that the repairs weren't done properly. So they had issues with that, and so they agreed on the amount that it would take to repair these things, and then got upset because they felt like it wasn't disclosed on the front end that this respondent's spouse was doing the repairs, and so it looked to be misleading in their opinion. And the only issue that I had with it was that in addition to doing the disclosure, the respondent should have obtained written consent, and that they didn't get written consent about that.
They had to get written consent over who they were going to get to do the repairs?
Because there's a conflict there, and there is an interest that the respondent technically has, a personal interest with respect to this person who's the spouse doing these repairs.
I move to dismiss.
Second.
We have a motion by Mr. Wood, seconded by Mr. Douglas, that this complaint be dismissed. Discussion? Those in favor of that motion, vote aye.
Aye.
Those opposed, vote no. That motion passes unanimously. All right, we have a couple of represents.
I
Let's
just read the new information.
Right, read the case number to the record.
Okay.
We'll go with-
2019-038301. Respondent contacted counsel regarding the failure to disclose their status as a licensee. Respondent stated that complainant's agent was aware of their status as a licensee prior to negotiations. Counsel reached out to complainant's real estate licensee and received confirmation in writing that complainant's counsel was aware of the respondent's status as a licensee, but was unaware that respondent intended to personally purchase the subject property. Respondent did provide the disclosure in writing and received the written consent of the complainant. The written disclosure was not provided to complainant until the date of closing. However, respondent did disclose to complainant's licensee their status as a licensee and that they intended to personally purchase the house well before the closing. So the issue before was that they just didn't disclose it until they were up against the wall and at closing. But what really happened was the respondent told the complainant's licensee that they were licensed and that they were going to buy it before the closing. So it just was a lapse in communication between the complainant and their licensee. So I recommend dismissal.
Motion to accept counsel's recommendation.
Motion by Mr. Diaz, seconded by Ms. Taylor, that council's recommendation be adopted and this complaint be dismissed. Discussion? Those in favor of that motion, vote aye.
Aye.
Those opposed, no.
Commissioner Grease, I'm going to abstain from voting on this one.
Okay, so that motion passes on a 7 aye, 1 abstention vote. Mr. Wood abstains. 29.
2019-035041. New information. Respondent's attorney contacted counsel following the October meeting and stated that they do not operate as a rental location firm in Tennessee. Respondent stated that they are exempt under TCA 6213-104 as they do not undertake leasing directly in their Tennessee office but rather function as property managers. Respondent states that they do have independent leasing agents who have entered into non-exclusive listing agreements with respondent. Respondent provided copies of licenses of the affiliate brokers involved in the business of listing rental properties and a copy of the listing agreement. Counsel reviewed the documents provided, and it appears that the respondent operates as a property management company and has some licensed independent real estate licensees who maintain listing agreements with the respondent. Counsel recommends dismissal.
Motion to accept counsel's recommendation.
Motion by Mr. Diaz, seconded by Mr. Moffett. The council's recommendation be adopted and this complaint be dismissed. Prior to voting, I have a question. So these independent real estate licenses, is it your assumption they're licensed with other real estate companies?
Correct. They're affiliated with a different firm, not with this particular company. They're independent contractors.
So what do they do?
So they list the properties and they show them and they create the leasing agreements. And
So any commission that comes from that goes to the company they're licensed with, not to this respondent.
Right.
You're comfortable with that?
Yes.
Okay.
They gave me the contract that they have with those licensees. So I reviewed it. And it seems like for what the complaint was about, it appears that, who it was against, it appears that they really just operate as a property management company and not as a rental location firm.
Other questions? Let's vote. If you're in favor of the motion to dismiss, please vote aye.
Aye.
If you're opposed, no. That motion passes unanimously. 30, new information.
2019-044931. Council reached out to respondent requesting a copy of the property which one am I on? Oh, okay, sorry. Council reached out to respondent requesting a copy of the property management agreement. Council reviewed the agreement provided, and it does indicate that complainant was to provide 60 days written notice of termination of the contract. Complainant did not provide written notice to respondent. Additionally, after reviewing the contract, respondent's only duties involved the collection of rent money. Therefore, respondent would be exempt from the Real Estate Brokers Act under TCA 6213-104. Council reinstates the recommendation to dismiss.
Move to accept.
Mr. Diaz makes a motion to accept council's recommendation. Ms. Taylor seconds that motion. Is there discussion?
Were these the people that, after their agreement was over, they were still collecting rent and keeping money?
So the agreement said, and the issue was that they were saying it was their policy to continue on, and Commissioner or Vice Chairman Franks wanted to know where it said that in writing. So I got the management agreement, and they were required to do 60 days notice if they wanted to end the contract, and they just didn't provide them with that information. So yeah, technically this is what the one you're talking about, but the issue wasn't about them continuing on. It was about it being in writing and whether they had communicated that.
The questions? If not, let's vote. If you're in favor of the motion to dismiss, please vote aye.
Aye.
If you're opposed, vote no. The motion passes unanimously. Thank you, Kristen. Ms. Matlock.
I think I have one more.
One more?
I'm sorry.
You
I'm
want more?
very lengthy today.
No, it could be us.
No, it's
I'm
not
sorry.
y'all.
Go right ahead.
Okay, 31-2019-037951. New information. In respondents' initial response, they failed to include a copy of the timeshare contracts that included the proper rescission language. Respondents' attorney contacted council asking if they could submit a copy of the contract with the required language. Council received the copy of the contract, and it appears that the incorrect document was initially filed. However, the additional documentation provided to council did include the rescission language as well as the signatures of the complainant and the respondent. So council recommends dismissal.
Recommendation to accept council recommendation.
Motion by Ms. Taylor, seconded by Mr. Moffett, that council's recommendation be adopted and this complaint be dismissed. Discussion. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Thank you, Ms. Kristen.
Thank you.
Okay, Ms. Matlock.
Okay. Number 32 is 2019-031651. New information. The commission requested this complaint be deferred until the conclusion of the annual Arello event. Based upon the information learned at the conference, council reinstates the recommendation for a letter of warning. So my recommendation is a letter of warning.
Recommendation to accept council's recommendation.
Second.
Okay, Ms. Taylor makes a motion to accept council's recommendation. Mr. Wood makes seconds that motion. My only question, Anna, is what new information did?
We didn't obtain any new
Oh,
information.
so there was no information.
So it was recommended that we defer it
Yeah.
until the meeting to see if other real estate commissions were regulating this type of and kind of thing, and they are not. So.
All right. Other questions? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
Okay, number 33 is 2015-0224121. New information. The civil case involving complainant as the plaintiff and respondent, as well as the home inspector as defendants, was voluntarily dismissed by complainant on July 8, 2019. Council has reviewed the entire department file as well as civil court documents and finds no evidence of any violations and therefore recommends dismissal.
Motion to accept council's recommendation.
Motion by Mr. Diaz, second by Mr. Moffett. The council's recommendation be adopted and this complaint be dismissed. Discussion. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. All right, Ms. Matlock, ladies, are you all done with us? So, just for the record, clearly we don't agree with each other up here, so occasionally if we don't agree with you, I hope you don't take it personally, because we don't up here. As a matter of fact, I sense you like the challenge. I don't know if that's true or not. All right, under legal update, Anna, were you going to talk about the rules at this point? Okay, this is part of what Bobby wanted to add to the agenda.
These are my rules, my proposed rules.
It was at my.
Well, are they related to Bobby's request? Or okay, let's talk about your proposed rule then.
So as we were stating prior to the Fresh Start Act, we had certain issues with 1260-01-.014. And so in consulting with the recommendation, with the notice of rulemaking should be, you have a red line on your iPads.
What's it titled?
It's the notice of rulemaking hearing red line.
That mean it would have on it?
Sorry?
The second page is marked through red.
Yeah. I feel
So it should be like the second page
Got
should
it.
look like
Okay.
this.
Got it.
And so I drafted a set of rules here. Well, I didn't draft, I amended the rules. So with this rule amendment, it would be amending the 1260-01-.01 applications for examinations. And it would remove the current section 4 and amend number 5 to remove notwithstanding the provisions of paragraph 4 of this rule, as this would remove it. And then we would be amending previous number 6 to state instead of all felonies, it would be felonies that are class A, B, or C felonies. And then there is an amendment to 6B1 to amend the all felony languages to class A, B, or C felonies. And then you'll see there's a new subsection D. That's actually not a new subsection. It is just the last sentence of the former removed section number 4. So what this would, the rule change would allow is for individuals that it would change it so we wouldn't have to see individuals that have class D or E felonies before us anymore. And it'll also remove individuals that are currently, it would remove the language that states that they are ineligible for examination unless 2 years have passed from the date of expiration of probation, parole, or conviction, or date of release from incarceration, whichever is later in time. So that's what this rule would change. As you know, the Fresh Start Act was passed, and the Fresh Start Act states that any rules, any convictions that directly apply to the profession, so that would be theft of money, property, or services, or convictions of Class A, B, and C felonies have a presumption that they apply to the profession. So there are certain, our rules were too broad based upon this, and the whole spirit of the act, as you know, is to allow individuals to be able to be licensed. And that's basically all that I have here. This would change, as we know, the individual that was here before this morning that was still on probation. He would still have to appear before us because his conviction was still within 10 years. So the 2 years date is most likely still going to catch people because their conviction is within the 10 years, if that makes sense. So it's just not, it's removing that blanket bar from saying that they can't apply for examination or be considered for licensure, because we cannot do that.
So if we had three informal applicants this morning.
Yes.
So the lady with the bad check.
Yes.
But that she
She would still have to appear because that's a misdemeanor for theft.
And the guy who sold some heroin.
Right. So I believe he actually had a Class C felony, but the Class C felony, if we look at the Fresh Start Act, falls into the drug crimes section, and so they would not appear before us.
So drug crimes would be out.
Right. So it's the drug crimes would be out.
What else would fall under Class C, and for people who would not have to appear before us?
So it would be, there aren't very many Class D or E felonies. We usually don't get people for those type. I'm not even sure what D or E felonies would be, but the severity is A is the highest, E is the least amount. So we're still catching the people that have those that are the most severe felonies.
I guess my question would be, what if somebody had committed multiple Class C felonies?
Multiple Class C felonies, they would still come to us because this Class C felonies, there's a rebuttable presumption that it applies to the real estate that it applies to your profession. So
help me understand again, who does not have to appear before us
people
with your
that
rule
would
change?
be convicted of Class D or E felonies.
Oh, D or E, okay. What about if someone had committed multiple Class D felonies?
And they would not need to appear before the commission. I can give you like an example of what a Class D or E felonies in Tennessee. I can give you like an overview of what Class D felonies. Class D felonies are mostly going to be some of your drug crimes, and Class E felonies. There really aren't that many Class E felonies that would fall into this, but theft of property is one of those. However, we have that in our statute that theft of property would still come before us because it's the real estate profession.
And so is it your goal today to get us to vote on this, or are you just giving it to us so we can vote on it next month?
I would like, if there's any discussion on this particular rule change, I would welcome that, but my goal is to get a vote so we can move it through the process so we can have a rulemaking hearing.
The process is an arduous hearing. Arduous process.
Yes. So this is something that we have to change because of its outside of statute. And so we would, following this, I would route it within the department, get it approved, and then it would go to the AG's office for constitutionality. I've already consulted with an attorney general prior to see if this would get us in line, and I think this is one of the recommendations. I went with theirs. And then we would go to the governor's office for approval, and then once we get that, we would file it with the Secretary of State. And so we have the hearing after 52 days of filing.
So next Christmas.
No, it wouldn't be next Christmas. So if we were to get this approved by the department by the end of this month, we could probably, I would say probably March would be when we would have the rulemaking hearing.
So is the hearing after all, like the governor and the AG approve it?
So after their initial pre-review, so after the hearing, if we have people that come in for comment, we put it on a different form. So if you remember the form that asks the questions about small businesses, we would put that on the form, send it back to the AG's office for signature, and then we would go to Government Joint Operations Committee.
Yes, question. It's a best case 6 to 8 month process.
Right. So for like the internal metrics for proposed rules, it's 9 months. For rulemaking hearing, it's around 9 to 12 months. But as I was saying before, I think if we were not to have a lot of obstacles, we would probably be on the end of 9 months most likely, because we meet every month.
Okay. But what would be council's recommendation as to what the motion should say?
So if you approve the language as here, we would just need a roll call vote if this is approved, so I can go ahead and get it through the process.
Mr. Chairman, I'll make a motion to approve the amendment to the rule as submitted.
Is there a second?
I'll second it, but
Okay. So the motion is made by Mr. Diaz, seconded by Ms. Taylor, that the language submitted by council is acceptable and should be forwarded to the appropriate parties. Ms. Taylor.
it seems to me most of the crime are with drugs in some sort of manner. And it looks like we're just wiping out most of the drug-related crimes here.
The lower offending drug crimes. So part of the that's part of the reason that the Fresh Start Act was passed, is because they were seeing that certain individuals were not being able to obtain their licenses due to things in their past. So it's to essentially give them a fresh start with that. However, not all drug crimes are misdemeanors or D or E felonies. If it's a severe drug crime, it would be something that would come before us. So it's more likely to get people that are, so for example, when I was looking up Class D felonies are usually someone that has a marijuana crime. But if you're using, I guess, what the drugs consider like cocaine or heroin, or as the individual that was here earlier, that was cocaine crime, that's a Class C felony. So you would still come before us with that. It's to allow people that have the, I guess, smaller drug crimes to be able to obtain their licenses instead of being held back.
So in your review of the statutes, that the drug crimes that fall under felony D and E tend to be low weight possession.
Right. So
kind
if
of
you're,
crimes.
we're talking about smaller drug crimes. So if you're moving, obviously, if you're moving, for example, pounds of marijuana, that's not going to be
That's
a class
the distribution and sale
D or E.
kind of thing.
It's going to come with a harsher penalty.
Yeah, so if you got weight where you would look like a distributor or a seller,
Right.
then that would rise in severity as opposed to a D and E
That's
felony.
correct.
Okay.
Okay, the motion on the floor is to approve the language presented to us regarding this particular rule. More discussion? Excuse me. If not, let's vote. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. All right, Ms. Matlock, you're free to keep it moving as fast as it can move.
Do you mind if we do a roll call vote for this so we have it?
Who suggested?
I said it before when I requested.
I can tell
I'll
you.
do it
I can
quickly.
tell you how it will go if you want me to tell you.
It's one of those procedural steps we have to take.
Roll call vote, please.
Okay, Commissioner Joe Begley. Yes. Commissioner Jeff Diaz.
Yes.
Commissioner Rick Douglas.
Yes.
Commissioner John Moffett.
Yes.
Commissioner Fontaine Taylor.
Yes.
Commissioner Stacy Torbett. Commissioner Bobby Wood.
Yes.
Chairman John Grease.
Yes. Don't you think we could save a lot of time by not putting the the word commissioner in front of each person's name? Can you just call the name out? Just a thought.
could.
It's rhetorical. You don't have to answer it. I just put it out.
I'm sorry, I
But
like
now-
hearing Commissioner Diaz. I mean,
Well, call Diaz commissioner, all right? All right, now, can we get to Bobby's stuff? Okay, let's start with your proposed rules.
Well, can I talk about a couple other things first?
You can do whatever you want to.
At the national, I'm just really going to first brag on Marcia Franks. Since she's not here, I'll brag on her. But at the National Association of Realtors meeting, they had a panel discussion, and it had to do with basically real estate commissioners and real estate commissions and how they tie into the MLS, and how in some cases they actually work hand in hand. And so Marcia got to represent Arello in our state and did a great job. There was 4 people on the panel, and so she did a great job doing that. But coming from that, one neat way that, and I believe it was Idaho that works together with multiple listing services, the concern that they had was, like for instance, if we take away somebody's license, that if their license gets suspended or revoked or whatever, or if they expire, the first thing that those licensees are not thinking of, quick, let me go tell my MLS so they can shut me off. Actually, that's one of the last things they think about doing, they want to do. And so in Idaho, their real estate commission sends out a feed that notifies MLSs in the state and just says, these people's license status has changed. Not only, it could be anything from they retired their license. You can go to the whole gambit, and then all the way to people who are new licensees. But they just do that on a regular basis, push that out so MLSs will have access. And it doesn't just have to be MLSs, it could be Association of Realtors. So you could see, we were pointing out today, we got somebody who was a bad egg, and after 7 months, we're just now getting around to them. And then how long is it going to be for their MLS finds that out? So, and that's really more of an IT kind of thing, if there's something that they could do. And so that's really the first thing I kind of mirror with that. But the other thing that we've talked about for quite some time with our IT people is, can we make it where, I think you already addressed it, Caitlin, if it's a licensee, can we show the name of the brokerage that they're at? And I know some of them are there. There's a lot that aren't. And then the next step was, if it's a firm name, can we not show who the managing broker is or the principal broker? So if in case there's an issue, that other brokers can reach out to other brokers. And is that something you think IT can work on?
I think definitely the firm is something that we can work on in the immediate future.
Okay.
And I think probably the broker is something that when they just end up switching systems is something that we can look at. But in the immediate future, I had actually reached out not too long ago about why some agents show their firm and why some don't. And there's an additional spot that firm has to be in core. That's where it's pulling from. So it's a project that is on my radar to get it to where each agent has that firm information.
But I guess if we could just kind of put that on our radar and something that we can reach out to them about those things. And if you would just check and see if there's any way they could, what would be required in order to send out information about suspended licensees and stuff like that?
So we do, and actually Aaron works pretty regularly with our contact from the MLS about statuses. And we actually were discussing a more effective way to do it that's better time-wise. I know they probably don't want to do you know how often they're sending that to them?
I did not get the feeling it was a daily thing. It was more of either a weekly or a monthly thing.
Okay.
And it was not anything that they were manually. They called it a push feed, and basically it was an automatic thing. At the end of a certain time period, it just sent it out.
So we do send that kind of stuff out frequently with the public records request. We want that request in writing. So it's something that we could talk to them about. My understanding is right now she's contacting us definitely weekly.
She being somebody from an MLS?
Mm-hmm.
Is it a local, or do you know where the MLS
She's in
is?
Tennessee.
Okay. Knoxville does that? Okay. Okay. Okay.
Asheville. Mhm.
And talk about what we talked about last month? Yep. Let me see if I can find my notes here. Okay. So what do I need to do? I mean, I think we got some information back on the things that I proposed last month, and then what is my next step if we want to go forward?
Well,
We
I
need to
think-
vote on stuff, or
So you made 7 proposals.
okay?
Staff has determined that 4 of them, 3 of them.
Wait.
How many can we actually deal with? We can deal with business cards and getting permission to advertise the house. Okay, so the proposed rule is listed on what was sent. Did you get this?
I did. Mine's not colored, but
I
that's
have
okay.
to color code it.
Okay, that's
That's
okay.
what I'm talking
It's okay.
So, on 3A, the proposed rule the proposed rule is 3B.
Yeah, and it just basically says
Add business cards.
make some advertising and not
Yeah.
not advertising.
Yeah, by inserting 2 words, that takes care of your concern.
Right.
So if you like that language and you would like to make a motion to approve that language to get this thing moving, you can do that at this point.
Okay, then I'd like to make that motion then.
Second by Mr. Moffett. So if this motion passes, just like the previous rule we dealt with, this will start the procedure to get this thing codified as a revised rule at some point, hopefully. Okay, so all we're doing, net, is the bottom line is that business cards would be considered advertising. If you believe that's good, then you'll vote yes in a second. If you don't, you vote no. Any discussion? All right, let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. So that's going to track with the previous rule we've discussed. And then the other rule we can deal with has to do with the current rule that says you have to get permission from the owner to advertise property owned by that owner. That's the current rule. The proposed rule of Mr. Wood would be that you have to get written authorization from either the listing agent or the listing broker. And so the change in this rule is to add, no licensee shall advertise property listed by another licensee without written permission, with written authorization from the listing agent or the listing broker. If this became a rule, you no longer would have to get permission from the owner of the property, just the agent for the owner.
That's a motion I'll make.
You like this language?
Yes, I do.
Okay.
I just think the previous language was antiquated. I mean, I think it kind of goes back to the days of, newspaper advertising when that was really the only thing you could do outside of a sign. But I look nowadays, I mean, every one of us have got every other agent's listings on our website. But we don't have everybody else's permission to do it. We have it through IDX. But if you go to run an ad in a local newspaper, necessarily, you're going to have to ask permission and get the seller to sign it. I think it's antiquated.
Is this, sorry to interject, an and/or thing? Like, these people would still be getting permission from the owner?
No, the listing broker or the
But the listing
agent.
broker would be getting permission somewhere to advertise it and allow others to advertise
Well,
it.
the listing broker, when they go and list the property for a seller, it gives them permission to advertise the property in that listing agreement. So,
Okay.
so the listing broker got permission when they listed the property.
And then that permission would then be turned over to the listing broker to
Do
allow
whatever they
others.
think is best to market the property.
Okay.
And if they think it's best to let somebody else run an ad in the local paper about it, then they do it.
Conceptually, we don't care who sells it. And so if somebody else sells it because of their efforts to market that same property, You're okay with that?
That's right. You're still getting paid.
So would the listing broker, listing agent need to disclose that they would also give permission to other agents to market their property? Would that be something they need to do?
No, I think this is done so infrequently that it's kind of done on an individual basis. I don't think you would want to just do a blanket for everybody. I mean, if you do, swell, but I don't think most people will do that.
Okay.
Bobby, I've seen some things lately. Neighborhood property. This will entail that, so, right, should they, and
But websites are different because, like in our area, you're getting permission to put other listings on your website through an IDX or VAL agreement.
these
So-
other these other, like, not Quicken Loans, but, what's, No, the, Zillows and things like that.
But they're getting it a feed from your MLS listing. Because like in our MLS, you click, do you want it to go on the internet or not? And when you do, it goes everywhere. And then once you put it out there, everybody can basically scrub it or grab it and copy it and put it on their site. I mean, it's out there.
So you're saying it's okay for these little people to take
Well,
a neighborhood website?
yeah, I don't know that I can.
Okay.
I mean, I don't know that I want to get that deep in
Yeah,
the
well, I'm
bushes.
just trying to
so.
see how far this
Yeah.
goes. Okay.
So you're saying that, I'm sorry. So you're saying that if it's on syndicated to Zillow and other sites, then I'm also giving permission to other agents to take it and put it on their site like it's their listing, or do they
No,
have to say
this has
that?
got nothing to do with syndication. I mean, this is, if you're syndicated, you've already given everybody permission to advertise all your properties on their sites. So this is more of a local, can I advertise your listing in the local paper? Because that's not handled through syndication.
Would I put on that advertisement that the listing's provided by so-and-so?
No, I mean, it's whatever you negotiate at that point. Because most time when somebody comes to me, they go, I don't have anything to advertise. Can I advertise that listing you got? And I'm like, sure, spend all the money you want. Because I'm going to get paid when it sells anyway. But I want them to ask me first, not afterwards.
Okay, the motion on the floor is to accept this revised rule as presented. Further discussion. Let's vote. Those in favor of that?
But we need a second.
Pardon me.
Sorry, we just had a motion.
Is that a motion? And you want a roll call, too?
Oh, we didn't.
No.
No second.
We just want a second.
I'll second.
I think I heard the second from Ms. Torbett. I think I heard it earlier, but she's said it a little louder this time. Just so quiet is right. You don't want a roll call this when we did the others. We had to recall. Oh, you'll bring us the language back next month.
We'll put it in the proposed
Format. Got
yes.
it. Okay, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. What else, Ms. Matlock?
I was just going to say.
What else, Ms. Maxwell?
Sorry. I was just going to quickly say, because a lot of these are specific to the industry, we probably will next month bring questions for you all to assist with that would relate to how this would affect small businesses, how it would affect the consumer, how it would improve protection for the consumer and that sort of thing. So if you want to go ahead and be thinking about those kind of items, that would be helpful for us.
Want to send them to us early.
Okay. I will do that if my legal counsel will allow it.
Keep shifting and write down the trade. All right, any other business to come before the commission? So we just do this in case somebody wants to say anything. We'll go around the horn real quick. If you have any comments, feel free to make them. Mr. Douglas?
I don't have anything, thank you.
You going to watch YouTube videos on the way back?
Don't say it. Don't say anything. Don't say anything.
I don't have anything.
He will be at 10 and 2 with eyes on the road.
No, it's just good to have a big group again. We miss Marsha Franks, but not being here. She got a little under the weather traveling, but it's been good to have our new commissioners with us.
Absolutely. John?
Well, that's good to have.
Here's what's good. Last month when we last saw John, he looked like he'd been in a fight. I mean, he had hit a
It looked like he won, though.
crossbar, and it was banged up beyond recognition.
Yeah,
almost.
he looked like he won.
You pretty well hit. The concrete won. And I'm glad you're better. Ms. Taylor?
I welcome the new commissioner. Really glad to see
Jeff? Oh, you want to say anything?
Glad to be here.
Oh, that's great. We got to have you on the record. Stacy?
Glad to be here.
I'm glad you're both here, too, after yesterday's experience getting here. I hope you'll come back next month. That's what I'm most concerned with at this point.
Hey, Ms. Maxwell, can they get red books to take home with them at some point?
I would love to say yes,
They're
but I
outdated at
can't
this point.
officially say yes because those are very hard to come by.
We'll figure it out.
But we'll see what we can do.
I'm from T.
what?
I said they're outdated at this point.
They are outdated at this point, so
But we'll figure it out. Okay. Everybody, I hope you have a happy Thanksgiving. We're glad you're both here with us. We hope you're going to be careful getting home. You get home before daylight. Let's get out of here. We're adjourned. Yes.
Safe travels.
Oh, yeah, I got to talk to him. My She's disabled.